Needham 1. 1 roger.
521.
Starting a card for a parking problem.
And 423.
Yeah, we're going to 28 from 1. Truck when you're ready.
Go ahead.
1 truck, White Lincoln X-ray 985 should come back up next.
So you had 2000 Patrick Spalding.
10-4. If you can just put a little note in something like that, I'm going to be leaving a note on a vehicle and driving him to remove it.
Rockingham 505. 505 entered vandalism case for Athens. Complainant, soon to be ex, slashed her tires and has made threatening comments to her. She's concerned he might return.
Yeah, forgive this at 32.
10-4. You're assigned to a vandalism case in Athens. Did you copy the 505?
Yeah, 4. Look at that.
21.
No 3 in Depot Street. Truck way entry 5.
7435.
10-4.
10-4.
You go there, 43 again.
143.
You go with that 43 you had. I didn't hear any, but I did just looks like we do.
10-4. I just wanted to know if you should be put back 76 to Cabana Circle or to the subject's address.
Yeah, I'll be 23 back on that.
All right, guys. Sorry, technical difficulties. You know how it is. Hopefully, we're back, but my camera was set up and then it was out, and that's always a fun way to start your morning. So I had to reboot the computer, even though I rebooted it before this morning. All right, guys. I'm halfway through my coffee, but fortunately, Jen Cofferdaffer is here to save the day. Good morning, Jen.
Hey, how are you?
Sorry about the technical difficulties. Damn computers.
We just appreciate you doing this, really setting up this stream and everything. I know everybody's very appreciative. I am, and I don't say it often enough. Thank you, Kevin.
You're welcome. Thank you. It's a long, long day yesterday, so I'm still trying to have the coffee hit my system today. But so did you have any insights as you had? Yesterday was a huge day in court. So I'm just wondering if you had any new thoughts or observations having processed all of that.
I think it was important to kind of watch all the drinks going down. I think that previously, even though we had strong testimony from the scientist who did her blood alcohol, some people were saying, well, yeah, but it's, within this range. I mean, when you see someone at her stature in such a short amount of time consume 8 drinks, it really hits home, I think. At least it did for me. Blood alcohol is a number, but watching it is a little bit different. That was one thing. And I think most people understand that a lot of times alcohol in excess like that fuels bad behavior. You were a bar owner. I'm sure you saw it time and time again. People who might normally have more self-control don't.
Yeah, absolutely. So does that in any way help the defense in the sense of where she could be responsible for the accident, but have some exculpability based on her alcohol levels and she's not aware? So for instance, she's charged with second degree, right? Does that somehow lessen the second degree aspect of it where she might not have been aware?
Well, of course, there's multiple charges on the table. There's the second degree, there's the vehicular homicide, or sorry, manslaughter. And then there's also leaving the scene of a crime where a person ends up deceased. So there's, a tiered level of what this jury could find. Listen, Kevin, from moment one, after looking at the documents, initially, I've said this before, I went in thinking, oh my gosh, do we have another Ellen Greenberg type situation? That's what I initially said. In fact, I had somebody DM me that was one of the ones, actually, I think there were 3 that initially put me onto this case or, asked for my opinion. But this one said, I wish I wouldn't have asked you because I think they were hoping, that when I dissected the facts that I would have come up on the other side. But having said all that, I've always said, and Yannetti said it from the courthouse steps, listen, this was not intentional. She did not mean to hurt him. Words to that effect. That's not a direct quote. She said, could I have incapacitated him, and in his drunkenness, he didn't move. So when you look at those things, I've always wondered why, Kevin, didn't she fall on the mercy of the court and just say, listen, I was wasted. I was blackout drunk. I don't even really have a memory. I'm unsure what happened. We heard testimony yesterday that she told Buchanan that she indeed did not see him enter the house. We've seen a lot of different statements from her. But the bottom line is, Kevin, I've always said this is a drunk woman who was extremely angry at that moment, who was in the middle of a breakup, really. He wasn't going to marry her. It was falling apart. They'd had the Aruba situation. And I think she knew it was coming to a close. And in a fit of anger, when she did that 3-point turn, she backed into him. And then she was just like, whatever, I'm leaving. And then as she starts sobering up, but this is the problem, I think. That grand jury saw something more than that, Kevin. Yep. We haven't seen it yet, and I think it's going to be in the information regarding the car movement.
Yes, I think so. I think you're right. So we'll see what it is. I just want to address. So Jason, we missed you yesterday, and I said that. I maybe you were here earlier. We appreciate, Jason, that you're a contrarian. Okay, but and so that there is a real value for that for someone. You don't want to have this echo chamber or this groupthink, and that's the problem with the free Karen Reed side, and we don't want to be that. So we appreciate you that. But this question, I want to point out the problems with the way you phrased this question. Kevin, will you admit no Proctor now? Now, there's a lot of problems here. Admit implies some new information has come out on Proctor that I'm in denial of. What? You shouldn't phrase it that way. Now, Proctor is testifying for the prosecution next week. So I don't know why you would say, well, I admit no Proctor now. Do you mean he doesn't exist anymore? I mean, it's just we haven't seen him testify yet. And it was a much smarter strategy to go with what they have. They could have either Proctor or Yuri Buchanan present a lot of this information that Buchanan presented yesterday. But since the defense has chosen to focus on Proctor because he has a distant connection between his sister to the Albert family. Doesn't it make more sense that if you have a choice, you're going to have Yuri Buchanan present some of these things? But we are going to see Proctor. It's just a smart strategy. So we love you for you being a contrarian, but try to word things in a less aggravating and annoying way, because that's an annoying way to word it, Jason. Okay?
You know, and I feel this way certainly on YouTube. I want to welcome people that have a different perspective, as long as they're talking about their perspective. At least he isn't, shouting belligerent statements at you.
No.
I block so many people because they just start out calling me the C word or an idiot or something else. I mean, I can't even get past the first sentence. And quite frankly, I just can't suffer fools. And that's what that is. That's just a fool that's coming on. I usually look before I block them, and they have 0, 1, 2, 3, people following them. In other words, they've just started. They did this specifically, probably offshoots from other people, right? Accounts that other angry people have, and they just have a million of them. So anyway, I have only one account. Like, I don't have a ghost account. Do you have ghost accounts, or should I not ask? You can just
No, I don't. No, I absolutely do not. In fact,
either.
I didn't start learning. I didn't even really start using Twitter until this past fall. In fact, Karen's friend Natalie had to teach me how to hashtag. So, I mean, I really didn't start using it until like September or October. No, that's it. I do have 2 accounts on my Facebook, one for the channel and one for myself, but none of them are hidden. You know that it's me, So no, I don't have any ghost accounts that are out there. I wouldn't even have time. Why waste my day doing that? It seems like such a waste of time. But
yeah, I don't have time to troll. I never go on anyone's account, except if somebody DMs me and says X, like somebody said something derogatory or is something interesting or something that they think might be helpful. It's not always negative. And then I'll go and look, and, I might heart it, or I might even make a reply. I don't know. I can't very well keep up with myself. I mean, I'm already starting to hire and ask for more help. Thank goodness my intern just started, and she's going to be amazing and be able to do a lot. But how do people have time to troll other people? They just must sit behind their keyboard all day and troll, I guess.
I mean, how do people have time to go to every single one of these trials? I don't, you're out there for every hearing, every trial. It just seems, I guess it's become their life and their social life. I'm not trying to take that away from them.
No, me either. No, now on the trolling I am, because there is no need. I understand trolling to find information, but I'm just talking about, when you're a goblin, right? When you're just out there trying to wreak havoc or just be vicious and nasty. I don't get that, Kevin. I love cussing and discussing crime. That's why I love the Twitter platform. I have never been around crime enthusiasts that know more and understand it and are true good sleuths. That's why it's invigorating to me to have these conversations on Twitter, and it's really, I love it.
Yeah, it stinks.
Lexus
You don't want to lose the
SUV owned by the defendant, Bear, Massachusetts, registration 3 GC 684.
Are we in? No, we're not.
No. This was from yesterday. So this is when I turned on the volume. I wanted you guys to it was good to see, though. This is you see Karen get out and go look at her taillight. So I think this was kind of powerful.
Exited that vehicle, is that correct, Sergeant?
That's correct.
Do you recognize who those individuals are as far as who they are and what part of the vehicle they exited from?
Yes, the passenger side exit was the defendant, and then the driver's side vehicle was Mr. Reed.
So she goes right back.
That's correct.
And I do, just for everybody that's watching, I have on my other computer next to me the trial up. So as soon as it goes into the courtroom, I will bring everybody in. I just want everybody to see this. Now, I have another one I want to show you guys. This is from yesterday that to me is even more powerful and really destroys so much of the conspiracy theory. This is the SUV being pulled up onto the tow truck in Dighton. And hopefully we get this here.
Yeah, you really have to keep your voice up.
Yes. Sergeant Buchanan, from this, still image from this video, what, if anything, is significant to observe in relation to the vehicle at this time that is being loaded onto the...
The rear taillight is illuminated. You could see a white light coming from that taillight.
If you could, using that laser pointing out for you, just direct your attention to the specific area you're talking about.
Right there.
Okay. Just if you could play this through.
I mean, so you can see it right there that it's clearly missing pieces. And the white light coming through because the red pieces, the red comes from the white light. There are on the, I believe, red LED lights on the taillight structure, but a lot of it also comes from white lights shining through the red plastic.
Yeah, I thought that was really compelling evidence. Although it's interesting, you still look on social media and, you know, this tail light project, you still see all of this sort of contradictory information showing different cars, different tail light, different housings. I mean, I don't know what all was created in the social media realm by certain people, but it's still floating around where people will say, see, look, but that isn't the right one. Well, it is. We're seeing the evidence. I mean, we're supposed to be judging this trial from what is being shown in trial. And so I think people on social media need to realize that what is out of trial is not being judged by these jurors, or it shouldn't be being judged by these jurors.
Jen, I wanted to respond to what you were just saying about the nasty side of what happens in chat. I've stumbled my way through this last year, but I've learned some things that actually might help you.
Oh, great.
So and again, not from any conscious decisions on my part, but just the way things evolved. So I think we have a really nice chat now where people are respectful to other people that come in with different opinions for the most part, and people are intelligent and asking questions. And most of that nastiness has been eliminated, but it wasn't like that for a time. So last summer, when I was first covering this and maybe leaning towards the conspiracy, the channel grew rapidly, but it was mostly Free Karen Reed, mostly turtle riders. And then as I was asking questions, they were turning on me, but they still liked my partners who were Free Karen Reed. And then when I finally had the quote unquote outburst episode where I yelled at Turtle Boy, they all turned on me. In fact, I lost like 800 subscribers in about an hour, which was a huge proportion of my channel back then. And then over the next couple of months, I lost my partners too. And my chats dropped down to where there might be only 30 people a show. But they started building back, and I still had my moderator with me, Tom, and he was keeping things civil in chat. And just over time, for a couple of months, as I was building back up, yes, there were people coming in and saying a lot of nasty stuff, death threats, even ordering me pizzas, giving up my address, reporting all kinds of false stuff. That turned out to be mostly a handful of people that once you blocked them, and they would keep trying to come back under a different name, but eventually they give up, and slowly they're just kind of weeded out. And now we rarely even have to block anybody now. So I think you have good moderators. I know if you do those lives, it'll build up to just people that like being in. It's not just about liking. They enjoy being with you or enjoy being with me. They enjoy being with each other once they form a pretty good group on their own. And I almost don't even have to be on the screen or even talking. So I think if you do that, you'll get there.
Yeah, YouTube for me, I've always been in just a different space, right? In really mainstream media space. And it's kind of interesting. The only reason I thought I should do YouTube is my SWAT team leader, my first one in Houston, a guy named Gary Steger. He died pretty recently. His wife and I were best friends when I was in the Houston division for about 10 years. And that combined with another guy named Mark, I won't say his last name, who actually was the individual inside Waco at the Branch Davidian compound, sifting
wow.
through the skulls and the debris. And he's the one that told me specifically they assassinated each person, assisted suicide before that place went up. And I was going to have him on my show. And he said, Jen, I have melanoma so bad. I look like Frankenstein. They've taken off my face. They're reformatting it. And I was just like, oh. And I started thinking, what are we doing not having these minds that are not going to be around forever, that have so much experience, that know about cases like the John Benet Ramsey case, that were in the middle of that case, and other cases, and just to have such great insight on the cases we're working now. And I said, oh my God, I've got to do a YouTube, not for them to pontificate about their cases, but to take that experience and bring it over to these two. So it's all new.
What's now open in ABCD?
Could I see counsel at sidebar about a couple of things, please?
Uh-oh, sidebars already.
Yeah. So I was told by Kevin Mahoney that if there was a problem in the way that Sally Port video was submitted yesterday, for instance, if it came in at the last second, that there might be a motion to dismiss, or actually a motion to dismiss the trial based on that.
How could that be based on that?
Well, if that evidence was held back improperly and only given at the last second yesterday, and they did view it in the voir dire before they let the jury see it, so we don't know exactly what happened there. Was that evidence discovered late and stuff like that? But to my knowledge, there's no motion like that to dismiss, and that would come today.
Well, there's going to be a motion to dismiss no matter what, right after the prosecution rests. It happens in every case. They're going to do it. I'm sure Jackson will make a strong argument for it from the standpoint of his standpoint. He's always so theatrical and has a lot of exuberance in his arguments. I mean, I see a lot of pros and cons with Jackson. I've had a lot of people ask me, if I were a criminal defendant, would I want Jackson representing me? I would not personally, not because I don't think he's good, because I do think he's good. I mean, this team has done their homework, and a lot of lawyers don't. So I give him an A+ in terms of preparation. But I guess if I was facing murder charge or something, maybe I would be unscrupulous, but I couldn't have somebody as unscrupulous representing me. I don't know how to say that, just in terms of everything we've seen. There's many others that are very talented and just as good as him that have scruples.
Yeah, it's really hard too. And I talked to obviously Kevin Mahoney and Joe Krauske and other lawyers and defense lawyers, and they have an obligation, they have a duty to try to defend their client as vigorously as possible. But where are the boundaries? So you're accusing, in this trial, innocent people of being part of a murder conspiracy. And where they seem to think, or at least where Kevin seems to think the line was crossed, was using social media. Because I think I don't want to put words in his mouth, but my understanding would be that a trial is supposed to take place in the court. And so if you're accusing somebody of possibly being part of a murder conspiracy, somebody potentially innocent, it doesn't really go outside of the court. Of course, the reality is trials are public, so it can go outside of the court. So I don't know. So these are difficult areas to where just seeing, I even thought that Yannetti, when he was up there trying to suggest that Allie McCabe was giving Colin a ride to the high school and making these trips back and forth, I almost sensed in his tone, I don't know if he was just trying to be sound sensitive to the jury, but that he felt a little squeamish doing it. Did you hear that at all?
No, not really.
Okay.
No, I didn't. I keep hearing Yannetti really with the same antics. I mean, I was just reviewing where as an example, this trial will never go on, you know, Morrissey's a target, the you know, the federal prosecutor, and they won't allow this trial to happen with all that's known. And then you see the statement right after that from the prosecutor saying, no one's a target, carry on, essentially. And, you know, and there's numerous examples of that. The 180, remember, where, again, sorry to regurgitate it again, but on the courthouse steps, you know, my client didn't mean to do anything bad, to now where, you know, third party culpating innocence. And I agree with your friend Mahoney, Mr. Mahoney, that's where it crosses the line when you specifically say that other people are murderers, and that you have this PR group doing it day after day.
Yeah.
That's where the line was crossed for me. And the other thing is, Kevin, and I've said this from the beginning, and a lot of people think that it's terrible that I say this, but I'm going to say it anyway, because I've been standard all the way through from the beginning, and I'll never end, is these hearings, these trials, I'm sorry, should never be public and streamed and on television, other than opening statements and closing statements. That's just my view. I think reporters should be there. The public should be there. We should, you know, absolutely understand what happens in there. But I just think it becomes such a circus. And when I see what the public has done to Jen McCabe, I'm just going to take that one small example on social media. That's why. Allie McCabe, destroying her on social media. It's just reprehensible.
Mm-hmm. Yeah, absolutely. So I guess today we'll probably go all the way through. They'll finish up with Yuri, but then the cross-examination is going to go at least till noon, and then we're supposed to wrap up at noon today. And then we're going to hear the cards team next week. So we're going to start getting to the really interesting parts of this case, what the state's theory is as to how the accident occurred, vehicle data, all that stuff is going to start coming out early next week.
Sure.
Hey. All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court, in for the copy of the oath. Draw near, give your attendance, and shall be heard. I say the Commonwealth of Massachusetts. This court is now open. You may be seated.
22117, the Commonwealth versus Karen Reed. Could I have the witness, please?
So, good morning again, counsel and Ms. Reed. Good morning, viewers. We appreciate your patience. Giving us this time actually helps streamline things today, so we appreciate that. I do have to ask you those 3 questions. Were you all able to follow the instructions and refrain from doing any independent research or investigation into this case? Were you also able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. Thank you very much. Everybody answered those questions appropriately. Okay, can we have Sergeant Buchanan, please?
You solemnly swear the evidence you give the court and jury in the case down here, and the truth, the whole truth, and nothing but the truth, so help you God.
I do. Thank you.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir. Good morning, sir. Circle back just to a couple things that from your testimony from yesterday. Going back to the video that you reviewed from both C.F. McCarthy's and the waterfall. In total, from those 2 videos, how many drinks did you observe the defendant consuming over her time?
The video shows 9 drinks being consumed.
by the defendant.
And that's between when she arrives at CF McCarthy's until the time that she leaves the waterfall, is that correct?
That is correct.
And if I could turn your attention to the ring videos from 1 Meadows Avenue, Mr. O'Keefe's residence. From the videos that you observed, let me ask you first, as far as, do you know how those cameras work as far as when they turn on and when they turn off?
My understanding is that ring surveillance video is triggered to be recorded through motion. So if the camera detects motion, which is constantly live monitoring, and motion is detected, then that video is captured to a cloud-based system that retains that footage.
And from your review of those videos, what kind of motion would set those off? Like what kind of things would be recorded from the driveway camera?
Be activity in the driveway, such as a person walking through, bird landing, a vehicle pulling in, individuals, moving around in the driveway, and so forth.
The search warrant that was applied for was any and all videos between January 24th and January 30th, correct?
For one of the search warrants, that's correct, yes.
And with respect to that time frame, what, if any, activity based on information that you had received was not available or was not shown on those ring videos?
The data returned had video that would have been captured from the defendant arriving home after midnight on the 29th, after she dropped Mr. O'Keefe off at 34 Fairview Road. That video was not present in the data that was returned from Ring. There was,
what, if any, other video in addition to that one was not present?
there was also video missing from the defendant showing Ms. McCabe and Ms. Roberts the damage to her right rear taillight.
And what, if any, follow-up or what, if any, inquiry was then done with regard to Ring as far as those types of videos or deletion, or how those videos could not be present?
Correspondence with Ring produced information that
Sustain.
Let me ask this first, was there follow-up with Ring in regard to those videos?
yes, there was.
And was there ever anything produced with regard to those videos or those timeframes from Ring?
No, there was not.
If I could turn your attention over to your time in Dayton, just in reference to subsequent to that later on, what, if anything, did you receive, or what, if anything, did you request? What, if anything, did you receive from the Dayton police in regard to January 29th, 2022?
I communicated with the Dayton Police Department requesting documentation from their officers' calls for service at our request, and log notes, logs from their dispatching center, as well as any reports that would document their activity if such reports existed.
And did you, what, if any, information did you receive in relation to that?
I received a log note or log printout from their CAD system, and I received a report authored by Officer Barrows.
And did you also receive any 911 calls?
Yes.
And who was the party as far as the 911 caller in regard to those 911 calls that you received?
It was Mr. Reed.
And again, just for clarity purposes, that's the defendant's father, is that correct?
That is correct.
And that's from the morning of January 29th, is that also correct?
Correct.
Now, sir, if I could turn your attention to February 3rd, 2022. At some point that morning, where did you go?
During the morning hours of February 3rd, we planned to meet at 34 Fairview Road. Myself, Trooper Proctor, and Trooper DeChico conduct a secondary search of the area as the temperatures were turning and the snow was melting naturally. We decided to do another search for articles that were now, we realized and learned, were missing and could be of evidentiary value and aid in the in the investigation.
And with respect to going to 34 Fairview Road, what, if any, tools or what, if anything, did you bring with you, you and the other troopers, in regard to conducting that secondary search?
I requested the troopers bring shovels, rakes, anything like gardening items that would help them to dig through the snow and locate any missing items.
And as far as the temperature change that you're talking about, how precipitous a change are we talking about?
The temperatures went above freezing, so the snow did begin to melt, and it was significantly warmer compared to the 18 degrees the night of the incident.
Now, you mentioned items of evidentiary value that you had learned of and were looking for. What, if any, clothing items, Mr. O'Keefe, were you looking for specifically on February 3rd?
We were specifically looking for Mr. O'Keefe's baseball cap.
And in addition to yourself, Trooper Proctor and Trooper DeChico, who, if anyone else, did you notify, who, if anyone, from any other unit within the state police responded that day as well?
We requested the assistance of the Crime Scene Services section of the Massachusetts State Police, and Trooper Evan Brent showed up to assist us with documentation of the location and the evidence that we were hopefully going to find.
And from those, Trooper Brent arrived and took photographs, is that correct?
That's correct.
And when was it that Trooper Brent arrived in relation to your arrival?
I believe he was already present when we pulled up, but I'm not sure to his exact time of arrival.
And with regard to that day, what, if anything, in general terms, what, if anything, were you able to locate and where was it, generally speaking?
We located Mr. O'Keefe's baseball hat. We located a drinking straw from a cocktail glass. We located items of plastic, colored plastic, and other shards of colored plastic at the location. All those items were located on the grass portion of the yard near the flagpole at 34 Fairview Road.
And Your Honor, may I approach?
Yes.
Your Honor, may I have a moment?
Yes.
And Sergeant, I'm going to show you a series of photos, but I'm going to break this up a little bit.
So, Mr. Lally, with your back to the jurors and the air conditioning on, I'm sure they can't hear you.
My apologies. So, sir, what I'm going to do is I'm going to show you some photographs, a series of them, but I'm going to break them up a little bit just to make it,
okay, sir,
hopefully quicker. Sir, first I'm going to show you 10 photographs. Ask if you could review those, look up when you're finished. Thank you. Do you recognize those, sir?
Yes, I do.
And what do you recognize those to be?
Those are photographs documented the items located at 34 Fairview Road on the grass as the snow receded through the melting temperatures that were revealed to be positioned in the grass.
And what's contained in those photographs, is that a fair and accurate portrayal of what you observed on the front lawn area of 34 Fairview Road on February 3rd?
Yes, it is.
Your Honor, may I approach?
Yes.
I'm off to introduce the minutes and next exhibits.
Any objection, Mr. Jackson?
No objection.
Okay.
It's 468 and 477.
Thank you.
And Your Honor, with the court's permission, if I could just ask to publish some of these photos.
Yes.
Just one moment, Your Honor.
Sure.
And Ms. Gilman, if I could start with photograph 7659. And Sergeant, do you recognize what's up on the screen and what's now been marked as exhibit 468?
I do.
And if you could, just for orientation purposes, describe to the jury whereabouts in relation to 34 Fairview Road we are in this picture.
As standing on the street of Fairview Road, we're looking at the left side of the yard. In the top right corner, you can tell that there is a flagpole depicted in that photograph and a telephone switch box that's open on the left side, which is on the border of 34 Fairview Road.
And if I could ask from this photograph, if you know, grass that's visible on the front lawn area of 34 Fairview Road, is that from a natural melting process, or is that from some tools that you and the other troopers brought to assist you in your secondaries?
The reason that grass is exposed is due to processing of the scene and having the snow being moved away from the location, and then natural melting process taking place on top of it. As you can tell, other portions of the yard is covered in snow, and the snow had not, the grass has not revealed itself just yet.
Now, as far as the photographs of various items that were located on this date of February 3rd, the photographs that were taken, were they taken as they lay, or were they touched or manipulated in any way prior to the photograph being taken?
The items photographed were discovered as soon as we realized what is being discovered through the digging and excavation process. They were then photographed instantly. Certain items were revealed naturally through the melting process and the snow, no longer concealing those items underneath.
Thank you. Ms. Gilman, can I have photograph 7666? Again, sir, do you recognize what's up on the screen? It has now been marked as exhibit 470.
I do.
What do you recognize that?
That is a clear black and red piece of plastic.
And Ms. Gilman, if I could have photograph 7669. And Sergeant, do you recognize what's now on the screen as exhibit 473?
Yes, that is another piece of plastic.
And sort of towards the top middle of the screen, do you recognize what that is?
Yes, that's a fire hydrant from 34 Fairview Road, grass area.
Ms. Gilman, if I could have the next photograph, 4670. For the record, this is exhibit 474. Do you recognize that, sir?
Yes, sir.
Is that a close-up image of what was depicted in the prior exhibit?
Yes, it is.
And Ms. Gilman, if I could have photograph 7672. And sir, do you recognize what's up on the screen, which has now been marked as exhibit 476?
I do.
And what do you recognize that to be?
Another piece of red taillight plastic.
And lastly, from dispatch, Ms. Gilman, if I could have photograph 7673. Again, sir, do you recognize what's up on the screen, depicted in what's now marked as exhibit 477?
I do.
What do you recognize that?
That is the fire hydrant and the telephone switch box located on the edge of the property line at 34 Fairview Road.
Now, the photographs that I had just placed before you, having had a chance to review those,
I have.
and do you recognize what's depicted in those photographs?
I do.
And what do you recognize those?
The property at 34 Fairview Road, left corner towards the street, capturing the flagpole and the telephone switch box.
Mayor Pro Tem,
Yes.
call multi to introduce and admit as the next exhibits. No objection.
Okay. Thank you.
Your Honor, with the court's permission, if I could publish a few of the photos from this set.
Okay.
Ms. Gilman, if I could have photograph 7681. Sergeant, do you recognize what's up on the screen? It has now been marked as exhibit 481.
I do.
If you could describe to the jury what's depicted in this photograph.
A red piece of plastic.
And Ms. Gilman, if I could have the next one, 760.
Can you use the pointer to show us where that is, please?
Yes, Your Honor.
All right, thank you.
Ms. Gilman, 7682. And Sergeant, do you recognize what's depicted on the screen and has now been marked as exhibit 482?
I do.
You know, I'm going to see counsel at sidebar for just a minute, please.
Not sure if you're here, Jen, but I'm curious if you've had any observations from what you're seeing there. That taillight plastic covered a pretty wide area for it to end up near the fire hydrant and kind of back on the lawn and stuff like that. So we know that from the testimony yesterday from the CERT team, O'Hara, from the day before, that 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 stuff looks like a lot of it was plowed up on the street, but then more of it ended up going back onto the lawn. So that was a pretty powerful impact that sent those pieces scattered over a fairly significant area. That's just something that I'm noticing here. This is Jen's time to make breakfast, I think, so she may be not hearing me. That's okay. But so I don't know if you guys noticed that. That's I think some people are probably wondering too if the fire hydrant was the source of John's injuries. I don't think that's going to be the case, but we'll see.
You are unmuted.
I'm sorry, Ms. Gilman, 7682. Sergeant, do you recognize what's up on the screen as Exhibit 482?
I do.
What do you recognize that to be?
A red piece of plastic.
That's the same piece of plastic that pulls our image from the prior exhibit.
Yes, it is.
And Ms. Gilman, if I could have photograph 7684. Sergeant, do you recognize what's up on the screen and is now been marked as Exhibit 484?
I do.
And what do you recognize that to be?
A white clear piece of plastic and a red piece of plastic.
And lastly, from this, sir, Ms. Gilman, if I could have 7687. So again, do you recognize what's up on the screen? It's now been marked as Exhibit 487.
I do.
Now, Sergeant, with reference to the photos before you, have you had a chance to review that set of 10 as well?
Not this one yet, not yet.
If you could, please. And Sergeant, do you recognize what's depicted in those photographs?
I do.
What do you recognize those to be?
Items that were located in the street, being the black cocktail drinking straw, and then black pieces of plastic, molding plastic, and clear pieces and molding from taillight.
Mayor Pro Tem.
Yes.
I'm up to introduce in minutes the next time.
Any objection, Mr. Jackson?
None, Your Honor.
Thank you.
Thank you. Your Honor, with the court's permission, if I could display some of these photographs of the jury.
Okay.
Ms. Gilman, if I could have 7688. And Sergeant, do you recognize what's up on the screen?
I do.
What do you recognize it to be?
It's the wide shot of the drinking straw being found on the edge of the roadway in front of 34 Ferry Road.
Sergeant, if you could, using the laser pointer before you, if you could direct the jury's attention to where you observed that straw. And Ms. Gilman, if I could have 7689. Sergeant, what are we looking at in this photograph?
It's a close-up view of the same straw.
Ms. Gilman, if I could have 7692. So Sergeant, do you recognize what's up on the screen and has now been marked as Exhibit 492?
I do.
And what are we looking at in 492?
Piece of plastic next to a measuring ruler that's provided for comparison and by the crime scene photographer to document the item.
And Ms. Gilman, if I could have 7695. For the record, this is now Exhibit 494. Sergeant, what are we looking at in 494?
It's the same item from just prior, just zoomed in more, showing the detail, the black molding, the clear white clear plastic and red plastic.
Sergeant, as far as those photographs before you, have you had a chance to review those?
Yes, I have.
And do you recognize what those are?
Yes, I do.
What do you recognize those?
They're pieces of red plastic, pieces of clear plastic, and a piece of glass.
May I approach, Your Honor?
Yes,
I'm about to seek to introduce in the minutes the next 10 exhibits.
No objection.
thank you.
It's 498, 508.
Thank you.
Thank you very much. Your Honor, with the court's permission, if I could publish just a few of these photographs for the jury as well.
Okay.
And Ms. Gilman, if I could have photograph 7700. For the record, this is now Exhibit 498. Sergeant, if you could describe to the jury what we're looking at here.
We're looking at a red piece of plastic next to a measuring ruler on the edge of the grass on the property at 34 Fairview Road by the road.
And if you could, sir, using that laser pointer, just direct the jury's attention to where you observe that item to be within this photograph.
Right there.
Ms. Gilman, if I could have photograph 7705. And for the record, this is Exhibit 502. Sergeant, if you could, again, describe to the jury what, if anything, of significance you noted there.
It's a shard of red plastic next to a measuring ruler.
Ms. Gilman, if I could have photograph 7708. The record, this is now Exhibit 504. Again, Sergeant, if you could, using a laser pointer, direct the jury's attention to what, if anything, of significance you know in this area.
There is a black piece of plastic molding next to a measuring ruler.
And lastly, from this set, Ms. Gilman, exhibit, photo number 7712. Again, for the record, this is Exhibit 508. And again, Sergeant, if you could, using the laser pointer, direct the jury's attention to what, if anything, of significance you know in this.
A clear piece of plastic next to a measuring ruler.
That's found on the grass area as well, is that correct?
That is correct.
Now, Sergeant, with reference to that new set of photos before you, have you had a chance to review those?
Yes, I have.
And do you recognize what's contained within those photographs?
Yes, I do.
And what do you recognize that those photographs to contain?
They contain small red pieces of plastic from 34 Fairview Road on the grass area where we located the others. Also contain a flimsy piece of circular, like very malleable plastic, clear plastic. In addition to that.
May I approach, Your Honor?
Yes.
Come up, seek to introduce the minutes next.
No objection.
Thank you.
Thank you. And Your Honor, may I publish some of these photos for the jury?
Yes.
Ms. Gilman, if I could have photograph 7715. For the record, this is now exhibit 511. Sergeant, direct your attention to the screen if you could, using that laser pointer, direct the jury's attention to what, if anything, of significance you observe in this photograph.
That is the thin, malleable, circular in shape, a piece of clear plastic that was located in the lawn area of 34 Fairview Road.
Now, lastly, Sergeant, there's that set of photos that I just placed before you. Have you had a chance to review those?
Yes, I have.
And do you recognize what's depicted in those photographs?
Yes, I do.
And what do you recognize those to be?
There are items. Those are items recovered in the lawn at 34 Fairview Road. Those items are a shard of glass, a BPD baseball hat with an American flag, and stains of blood.
Your Honor, may I approach?
Yes.
I'm going to introduce the minutes next.
No objection.
Sorry.
No objection.
It's 5:18 to 5:30.
5 what?
Thank
Thank you very much.
Thank you. And Your Honor, with the court's, sorry.
Jim.
Your Honor, with the court's permission, may I publish some of these photos for the jury as well?
Yes.
And Ms. Gilman, if I could have photograph 7727. For the record, this is now exhibit 520. And again, Sergeant, if you could direct the jury's attention to what, if anything, of significance you observe in this photograph.
I observed a shard of glass next to a measuring ruler.
And Ms. Gilman, if I could have 7729. For the record, this is exhibit 522. And again, Sergeant, if you could describe to the jury what we're looking at here.
It's a larger piece of red plastic with black molding around the edge, located next to the telephone switch box on the grass area at 34 Fairview Road.
And Ms. Gilman, if I could have photograph 7733. For the record, this is exhibit 526. And Sergeant, from this photograph, what, if anything, are we looking at here?
This photograph here depicts the area which we are excavating during the morning hours of February 3rd, 2022. As the shovel works its way towards the grass, my laser pointer is directing your attention to Mr. O'Keefe's hat that was compacted underneath the snow on the ground.
Now, as far as this photograph is concerned, does that accurately depict the depth of the snow that you were digging into and sifting through on the morning of February 3rd?
It does.
And that, again, is several days after the blizzard of January 29th, correct?
That is correct.
And Ms. Gilman, if I could have photograph 7740. For the record, this is exhibit 530. And again, Sergeant, if you could describe to the jury what we're looking at here.
We're looking at Mr. O'Keefe's hat on the grass, pressed down and compacted to a flat surface underneath the snow, which has been excavated around it.
Thank you very much. Ms. Gilman, you can take that down. Thank you, Mr. Ross.
Thanks, Jim.
Sergeant, on February 3rd, 2022, is that the first time that you had been at 34 Fairview Road?
Yes, it is.
And with respect, if I could turn your attention briefly to the following day of February 4th, did you have occasion to go back to 34 Fairview Road on that day?
Yes, I did.
And what brought you to 34 Fairview Road on February 4th?
Having excavated those items on the 3rd, I directed the troopers in my office, who obviously reside in the communities around us, to make a point to travel by that location every day on the way to work and every day on the way home. The purpose of that was to see if anything else was to reveal itself as the snow naturally melts away and items could present themselves. So on the February 4th, as I am traveling to work, I diverted my typical route of travel to go by 34 Fairview Road. Just prior to my arrival, I received a call stating that there was 10 police representatives at the scene, and more items have been revealed due to the melting snow, and that I should come collect those items. I was down the street. I arrived and collected the item that presented itself.
And if you recall, that item that you collected on February 4th, was that located on the lawn, on the street, or something else?
It was on the lawn.
Now, with reference to your collection of these items, either on February 3rd, February 4th, or on any sort of subsequent date, how were they collected, and what exactly did you do with them in reference to the seizing of the items and storage of the items?
Each item that was collected was placed in an evidence paper bag. The collection was done by utilizing latex gloves to prevent any transfer of evidence from fingerprints to DNA onto those items. Then those items were transported to our office, logged into the system, and stored in the evidence lockers at the office.
And each of those respective bags of items or evidence, they were sealed as well, is that correct?
That's correct.
Now, turning your attention to February 10th of 2022, did you have occasion to go back to 34 Fairview Road on that day as well?
I did.
And what, if anything, did you observe, or what, if anything, did you seize on that particular day?
We seized more shards of glass and plastic.
And if you know, or if you recall, how many pieces did you seize on that particular day?
My memory's exhausted to that, but exact numbers annotated in on the bags that the items were placed into.
Your Honor, may I approach?
Yes.
I'm showing you documents and steps to look at that section and look up when you're Your Honor, may I approach?
Yes.
Sergeant, is your memory refreshed as to how many items or what the items were that you recovered on February 10th?
Yes, it is.
And what were those items and how many, sir?
There was 6 items of clear red and black plastic and 14 items of plastic and glass.
Now, in addition to the dates that you were present at 34 Fairview Road and recovered items, them being February 3rd, February 4th, and February 10th, were there other dates that you're aware of that items were recovered by troopers that you supervised?
Yes.
And if you recall, what were those dates?
The dates were January 29th, February 11th, and February 18th.
Were there items recovered on February 8th as well?
Yes.
Now, as far as your direction or having, let me first start with you. So on the dates that you were there, February 3rd, 4th, and 10th, were you alone on those dates, or were there other troopers with you when you were there?
On the 4th, I was alone as far as state police personnel. There were other Canton law enforcement representatives at the scene with me as I collected that one item. On the other days, I was accompanied by other troopers.
And as far as you know, obviously not being present, but from your supervision of these troopers, were there other occasions where individuals were at 34 Fairview Road? Were they alone, or were they with a group of troopers?
Objection.
Sustained.
Now, as far as the items that were recovered when you were there on February 3rd, February 4th, and February 10th, did you have occasion to bring those items with you to court today?
Yes, I did.
And Your Honor, may I approach?
Yes.
I'm presenting you with a box. First, just ask if you recognize that box.
I do.
And what do you recognize that?
It's the box storing items logged into evidence as they relate to this case.
And Your Honor, with court's permission, may the sergeant open the box?
Yes.
Thank you. Now, first, Sergeant, with regard to the items, as far as plastic and/or glass that you recovered from 34 Fairview Road on February 3rd, if you could locate those items. And Sergeant, with respect to each of those bags, they contain items of evidentiary value, whether they be plastic or glass, that were recovered on February 3rd. Is that correct?
That's correct.
And I'm sorry, how many bags in total do you have there before you?
I have 3 bags, 2 containing broken glass and plastic, and a stirring straw, broken red plastic and clear plastic, and a bag containing 1 black Boston Police Department hat.
Your Honor, the Commonwealth will seek to introduce in minutes the next 3 exhibits.
No objection.
Okay.
No particular order.
Thank you.
Your Honor, with respect to what's now been marked as Exhibit 537, with the court's permission, may the sergeant remove that item, the hat, from the bag and display for the jury.
Yes.
Thank you, sir. You can place that back in the bag. And Sergeant, from your observations of Mr. O'Keefe on surveillance video from both C.F. McCarthy's and the waterfall on January 29th, what, if any, similarities did you observe between the hat you just displayed and located on the lawn of 34 Fairview Road and the hat Mr. O'Keefe was wearing in those videos?
It appears to be the same exact hat.
Now, Sergeant, with reference to the box of other items, if you could remove what, if any, items you recovered and seized from 34 Fairview Road on February 4th. And again, sir, just for the record, what's contained within that bag from February 4th?
Contained within the bag is a piece of red, hard plastic taillight cover.
Your Honor, the Commonwealth seeks to introduce in a minute the next exhibit.
No objection.
Thank you. Exhibit 538.
And lastly, Sergeant, with regard to the box, if you could remove the items that you seized from February 10th, 2020. And Sergeant, with respect to those 2 bags of items, if you could just inform the jury what is contained within those bags.
Bag labeled item number 10 contains 6 pieces of red, black, and clear plastic. Bag labeled number 11 is containing 14 pieces of glass and plastic fragments.
Thank you, Sergeant. Your Honor, the Commonwealth seeks to introduce and admit as the next 2 exhibits.
Any objection, Mr. Jackson?
I'm sorry. No, Your Honor. Thank you.
It's 539 and 540.
I'm sorry, was that 539 and 540?
Yes.
Thank you, sir. Moving on from that, if I could bring you back just one last time to the ring videos from One Meadows Ave, as far as you had testified earlier that there was no video that you observed of the defendant, Ms. McCabe, and Ms. Roberts looking at the passenger side taillight area of the vehicle, correct?
That's correct.
Was there any video of the defendant, Ms. McCabe, and Ms. Roberts actually leaving from One Meadows Ave on that morning of January 29th?
There was not.
Now, as far as the videos that were not there, as far as the defendant, Ms. McCabe, Ms. Roberts leaving, the next video depicted Mr. Camerano arriving at the residence to pick up Ms. Furbush, correct?
Yes, that's correct.
And with regard to the missing video of the defendant arriving at One Meadows Ave on January 29th, sometime after midnight, the video immediately preceding that, again, would have been Mr. Camerano arriving and picking up his daughter from One Meadows Avenue sometime around 11:30 p.m., correct?
That's correct.
And those videos were both present, correct?
That's correct.
If I could bring you back to February 3rd, 2022. On that date, did you have occasion to meet with a gentleman by the name of Brian Higgins?
Yes, I did.
And when you met with Mr. Higgins, who, if anyone from your office, was with you when you met?
Trooper Mike Proctor was from my office present during that interview.
And during the course of that interview, what, if any, documentation did Mr. Higgins provide you with?
Mr. Higgins provided me with a printout of a Celebread extraction containing conversations via text message between him and Mr. John O'Keefe and between him and the defendant. He also provided a digital copy of the same extraction on a CD.
Now, what, if anything, did you advise Mr. Higgins of at that time as far as Mr. O'Keefe's phone and the defendant's phone?
I advised Mr. Higgins that we were in possession of both of those devices and would have the extraction and accurate documentation of those conversations.
And did he seem to understand that when you told him?
Yes, he understood it.
Objection. Sustained.
Move to strike.
Strike that, folks.
Now, also on February 3rd, at some point, did you have occasion to go inside of 34 Fairview Road?
Yes, I did.
And who, if anyone, did you interview inside of 34 Fairview Road on that day?
I interviewed Mrs. Albert.
That would be, just for the record, Nicole Albert, is that correct?
That's correct.
And who, if anyone, was present with you during that interview of Nicole Albert?
It was Trooper Mike Proctor was present with me.
Anybody else from the Albert family present in the home or present during the course of that interview?
Mr. Brian Albert was also present. I don't know who else exactly was present in the home. I just know that those two residents were in the room with us.
And where was Brian Albert at the time that you conducted the interview of Nicole Albert?
In the room with us, seated next to her.
Now, with reference to, I'm going to ask you just a little bit about sort of the interview process as far as the interviews that you conducted in this case.
Yes.
If you could describe for the jury, starting with sort of how many people from your unit are present for a given interview and how those interviews are conducted.
We conduct interviews always in pairs. I think I mentioned it yesterday. Typically during a regular investigation into a homicide or any death investigation, we pair up our troopers with a local detective. In this instance, since Canton had recused themselves from interview portion of the investigation, they were not going to provide manpower for those interviews to be conducted. Thus, we had to utilize only troopers from our office in order to conduct those interviews.
And typically, obviously not perfect, but as far as the interviews that you were present for, about how long a period of time, generally speaking, were the interviews that you conducted in this case?
From my experience, I have learned that to fully communicate a course of recollection of events that an individual observes, experiences, or is aware of, and understand every detail of that experience, it would take approximately 45 minutes at a minimum to conduct a full interview with a witness in detail.
Now, sir, if I could turn your attention to June 9th of 2022. On that date, at some point, did you have occasion to meet with the defendant?
Yes, I did.
And at some point during that meeting, did you have conversation with the defendant?
Yes, I did.
And was that conversation, or at least portions of it, memorialized in any way?
Yes, it was.
Your Honor, may I approach?
Yes.
I'm showing you a disc. Does that contain an audio recording, to the best of your knowledge? Does that contain an audio recording of a portion of your conversation with Ms. Reed on June 9th, 2022?
Yes, it does.
Your Honor, may I approach?
Yes.
I'm about to seek to introduce the minutes of the next exhibit.
All right. No objection, Mr. Jackson? All right, folks, before we play this, again, please be mindful of the instruction from yesterday. So you're about to hear statements allegedly made by the defendant, allegedly concerning the crimes with which she's charged in this case. Before you can consider any such statement as evidence, the Commonwealth must prove to you beyond a reasonable doubt that the defendant made the statement she's alleged to have made and that she made it voluntarily, freely, and rationally. In determining whether the statement made by the defendant was voluntary or not, you may consider all the surrounding circumstances. These include when and where the statement was made, the nature of any conversations with the police or any questioning by the police, the defendant's physical and mental condition, including her intelligence, age, education, experience, and personality. Your decision does not turn upon any one factor, and you must consider the totality of the surrounding circumstances.
With the court's permission, may we publish that for the jury at this time?
Yes, do you want to turn off the air conditioning? Is this very short, right?
It is very short, and if we could, please, yes.
Yeah. And this is just audio, correct?
Okay, you're aware he was beaten up at Brian Conference. I mean, we're only on the same joke, right? My tail is correct and John was pulverized.
Thank you. Now, Sergeant, on hearing that statement from the defendant, what was your reaction?
Objection.
Sustained.
On hearing that statement, what, if anything, did you do?
I advised the defendant not to further speak.
Objection.
I'll allow that.
Now, at some point over the course of your investigation, were you made aware of forensic findings relating to the defendant's tail?
Yes, I was.
And specifically DNA findings?
Yes.
And specifically that there were...
Objection.
Sustained. Yes. You can turn the air conditioner.
Okay, we're in a sidebar. Lots of interesting stuff today so far, and it feels like more to come. They're clearly, Lally is using kind of a strategy here where he wants to make sure that the jury is aware that about the missing or the deleted Ring videos, but it sounds like he's not going to have Yuri testify about it. He's just trying to use a technique of setting the jury up with this information, building that expectation. That's what it seems like to me. But I'm very, as a writer, I'm very interested in the strategy. He begins today early on talking about the Ring video, then drops it deliberately, then comes back to it later. So maybe he is going to finish on the Ring video. I'm not sure. why they would try to build that anticipation.
You are unmuted.
But it's an interesting strategy.
I'm back. Have one moment.
Yes.
So Sergeant Mechanic, on January 16th, 2024, at some point in that day, did you meet with a Sergeant Gallerani of the Needham Police Department?
I did.
And who, if anyone else, well, let me ask you this. As far as any other troopers from your office, who, if anyone else, was there with yourself and Sergeant Gallerani?
Trooper Mike Proctor.
And what was the purpose of your meeting with Sergeant Gallerani, Trooper Proctor, on that morning?
Collection of our DNA.
And was that something that you did voluntarily?
Yes.
And how was it that the sergeant collected your DNA?
Through a buccal swab.
And were you present when Trooper Proctor submitted to a buccal swab as well?
Yes, I was.
And then as far as the swabbings that were taken from both yourself and Trooper Proctor, were those logged into evidence by you, or did Sergeant Gallerani take them with him when he left?
Sergeant Gallerani took him with it when he left.
Your Honor, may I approach?
Yes.
My apologies, Your Honor.
That's okay.
Thank you very much, Sergeant. Your Honor, I have no further questions.
Okay. Cross-examination?
Thank you, Your Honor.
Sergeant Butnick, I want to start with one of the latter things that you discussed with Mr. Lally, and that's specific to the ring video that y'all talked about this morning. Do you have that in mind?
I do.
The search warrant that produced, and just so we're clear, I'm talking about the specific ring video or series of videos that were associated with One Meadows, John O'Keefe's home.
Okay.
Okay. You didn't write the search warrant for those ring videos, did you?
I did not.
You were not the affiant for those search warrants.
I was not.
Who was the author of the search warrant and the affiant?
It was Trooper Mike Proctor.
Who received the actual ring video or videos from the Ring Corporation?
It was Trooper Mike Proctor received it.
And who ultimately either logged those into evidence or controlled those once they were received from the Ring Corporation?
I believe it was Trooper Mike Proctor.
And ultimately, Sergeant Butnick, you did note that in addition to just the physical videos themselves, that login information and login keystrokes, et cetera, were requested from the Ring Corporation as well, correct?
There was discussion with Ring asking for those logs.
I'll call it, is it correct to say an activity log?
That's what was requested, yes, activity log, yes.
So ultimately, the activity log would show who logs in, who accesses the data, things of that nature, correct? Or at least that was the hope.
That is what was requested.
All right. It would also show logging in and executing deletions, manipulating the log files, things of that nature, correct?
That is what was requested, yes.
When you reviewed those log or activity logs, there was no evidence revealed that my client ever logged into that account, correct?
There was no activity logs provided by Ring.
So you have zero, hang on. Isn't it true that Ring contacted Trooper Proctor and indicated that they had created a Dropbox folder that contained the evidence that had been sought in the search warrant?
Objection.
Sustained.
Isn't it true that the search warrant return specified account information, video recordings, and number 3, activity logs associated with video recordings are all times displayed in UTC?
I'm not aware of that, no.
Do you recall that activity logs were in fact provided from the Ring Corporation?
I do not recall that, no.
Okay. May I approach briefly?
Yes.
Take a look, Sergeant, at that paragraph, with my fingers on it, it's about the 3rd paragraph down the middle of the page, and review that to yourself and let me know when you're finished. Have you had an opportunity to review that?
Yes.
May I approach, Your Honor?
Yes.
Thank you. Does this refresh your recollection as to the items received from the Ring Corporation?
That is the first time I saw that document, so it does not refresh my recollection. I simply read it.
So do you have a recollection as you sit here that in fact during the course of your investigation, the 3 items that you received from the Ring Corporation were the account information, the video recordings, and quote, activity logs associated with the video recordings, all times displayed in UTC?
To the extent of its availability, as it says in that document.
Okay. The long and short of it is, during the entire course of your investigation, you never revealed that investigation never revealed any evidence whatsoever that my client ever even accessed the account information for the Ring account associated with this search warrant, correct?
Nothing provided by Ring proved or suggested or proved any evidence of that type of activity, no.
Thank you. Trooper Proctor, you were notified.
I am not Trooper Proctor.
I'm sorry. No, you're not. Sergeant Buchnick.
Sergeant Buchanan.
How do I say it?
Buchanan.
I'll give that a shot.
It's fine.
Buchanan?
Yes.
Is that better?
That's better. Thank you.
If I screw it up again, please. On January 29th, you were notified about a Boston police officer found gravely injured outside the home of 34 Fairview at about 6:40 in the morning. Was that your testimony?
That is not.
What time were you notified?
I was not notified it was a Boston police officer.
So you didn't have that information upon the first notification?
I did not.
Okay, what information did you have?
There was a male party in the snowbank, possibly of a heart attack.
At what point did you learn that the individual was, in fact, a sworn Boston police officer?
I do not know exactly when I learned that he was a Boston police officer.
I think it was during that day or the following day?
It was most likely that day, either. Yeah.
Fair enough. Trooper Proctor was ultimately assigned as the, what did you call him? Not lead investigator, but case officer?
That's correct.
He was assigned on the 29th, correct?
He was on call from 7 a.m. on January 28th until 7 a.m. on January 29th.
So his assignment was, he was assigned on the 29th because he was on call.
He was on call. His assignment took effect when the schedule came out back in mid-December.
Okay. Well, he wouldn't be assigned to this investigation until there was a need for the investigation, right? And that's all I'm getting to. And once the call came in, he was the assigned case agent.
Once the calls come in, the person that's on call is automatically assigned that case.
All right. Did you personally, as his supervisor, did you personally respond to 34 Fairview at any point on January 29th?
No, I did not.
Did Trooper Proctor, at your direction or on his own, ever respond to 34 Fairview Road at any time on January 29th?
No, he did not.
Based on your initial investigation, and I'm talking about going way back, Sergeant, on your initial investigation, by 10 or 10:30 in the morning, 10:40 in the morning, it was your belief that Mr. O'Keefe had been struck in the face by a person. That was your initial understanding of the circumstances surrounding the investigation, correct?
My initial understanding was that the defendant stated that she hit him. We did not know the...
Sergeant, you hadn't even met my client at that point. You hadn't interviewed a single witness by 10:41 in the morning, correct? Not one witness.
That's not correct. We had already interviewed the first responders.
Okay, when I say witness, I'm talking about civilian witnesses. So at 10:41, you hadn't interviewed a person at 34 Fairview or associated civilians associated with this incident, correct?
At that point, no civilians have been interviewed, no.
But at 10:41, Sergeant, you contacted Good Samaritan Hospital to inform them that, quote, Mr. O'Keefe was struck in the face with a cocktail glass, end quote, correct?
I do not recall contacting Good Samaritan Hospital.
May I approach?
Yes.
I'd like you to take a look at this document, and if you wouldn't mind, pay special attention to the second page, the bottom paragraph where it's tabbed in pink. You want me to approach?
Yes.
Thank you, sir. Having reviewed this, does this refresh your recollection that you contacted Good Samaritan Hospital and gave them an assessment, at least based on your investigation at that time?
That is not true.
What did you say to Good Samaritan Hospital?
I never spoke to Good Samaritan Hospital. That document is for the medical examiner's office.
I'm not asking you where the document is from. I'm asking you if the document says Trooper Yuri Buchanan called back at 10:41 stating the case is now being treated as a suspicion.
The objection sustained.
Did you call back to Good Samaritan Hospital and say that the investigation was being treated as a suspicious due to a domestic situation? Did you say that?
I never spoke to Good Samaritan Hospital.
Did you say that there's a possibility that D was struck in the face with a cocktail glass?
Objection.
Sustained.
Did you ever contact anybody at any medical facility and indicate that the investigation was being treated as a suspicious, in quotation marks, because the victim appeared to have been struck in the face by a cocktail glass?
Objection.
Allow that. Did you ever say that?
Yes, Your Honor. Yes, I did say that to the medical examiner's operations desk.
Okay, so when I was asking you if you ever said it to Good Sam, you said, no, that's not true. That's never happened. You were correcting me on the fact that it happened at the medical examiner's office, not at Good Sam.
I responded and answered your question honestly, yes.
Okay, so honestly, you did, in fact, at 10:41 a.m. indicate to another professional involved in the investigation that the circumstance was being treated as a physical assault at that point, correct?
I communicated our suspicions to the medical examiner's office.
And that was at 10:41 or thereabouts in the morning, correct?
That's correct.
Your initial investigation during those obviously critical hours, the beginning hours, led you to believe that there was at least a good possibility. You indicated that you made a phone call, that it was a physical altercation that led to John O'Keefe's death, correct?
That's correct, yes.
What steps did you take, sir, in those moments, to determine whether someone in the house at 34 Fairview may have been involved in that physical altercation that you suspected at the time?
As investigations develop, we followed the evidence and statements made. The steps I took was Trooper Proctor and I proceeded to an eyewitness who was also present at the scene when the victim was discovered and interviewed Ms. McCabe.
And prior to interviewing Ms. McCabe, by the way, that was at Ms. McCabe's home, correct?
That's correct, yes.
Even though you believe that there may have been a physical altercation, you didn't ask anybody to come down to the station. Is that right? Any of the witnesses?
That's correct.
And you did not seek to actually go to the physical location of 34 Fairview in those next few hours?
That's correct.
Or the next few days, correct?
Not myself, no.
Okay. As a matter of fact, Trooper Proctor did not either, did he?
No, he did not.
You didn't secure the interior of the house as a potential crime scene. You certainly know how to do that, right?
That's a compound question. Do you want me to answer whether I did it or whether I know how to do it?
Well, I'll ask the question. If you don't, if you can answer it, please answer it.
Okay.
Can you answer that question?
I can answer that question.
Why don't you answer both of them then?
First portion is we did not secure the home as a crime scene. And the second portion, yes, I do know how to do that.
And you didn't, as a Massachusetts State Police official, you didn't secure the outside as a crime scene either, did you?
I did not know.
To your knowledge, nobody else from Massachusetts State Police ever did either, did they?
Yes, they did.
How was that done and when?
When members of our office and the CERT team responded to that location and secured the front yard grass area and processed it.
That was at 5:45, 6 o'clock that night on the 29th?
I believe it was earlier, but I was not present, so I can't testify to the time.
So you don't know personally what they did to quote unquote secure or not secure the crime scene. You know they searched it, but in terms of securing it as a crime scene, you don't have personal knowledge to that.
I was not present.
Okay. You never took any photos of the interior of the house, correct?
I did not know.
You never caused CSSS to go inside the house and process that house as a crime scene, correct?
I did not, no.
No forensic criminalist at your direction ever went into 34 Fairview?
No, they did not.
And the people that you interviewed on January 29th, you already mentioned Ms. McCabe. The other people were her husband, Matt McCabe, correct?
That's correct.
And her brother-in-law, Brian Albert. Is that right?
That is correct.
And all three of them were interviewed where?
They were interviewed at the McCabe residence.
Now, yesterday when you testified, did you indicate that Brian Albert was not present in the home when you interviewed Matt McCabe and Jennifer McCabe?
They were not, he was not present in the dining room when we were interviewing each individual separately.
So if all three of them testified that he arrived before you arrived, they would all be wrong.
I did not see him in the home when we arrived, no.
I want to switch gears real quick to a couple of the physical items that you testified about yesterday, specifically the gray shirt or the gray hoodie and the orange shirt. You and Trooper Proctor collected both of those items you indicated from the floor of the hospital at Good Samaritan, correct?
That's correct.
You testified that you and Trooper Proctor immediately bagged both of those items. They were sort of sopping wet, I think you said.
That's correct.
You indicated that the bags were so wet that you had to take the items back out of the bags and then lay them out on, I think you said, butcher paper. Is that right?
The items were soaked and wet. They were bagged, double bagged, to prevent leakage of physiological fluids and the moisture coming off of it. And then once they were transported to the office, they were laid out on butcher paper in order to dry naturally.
So you went from Good Samaritan directly to Dighton, correct?
That is correct.
And then you went from Dighton directly to the Canton Police Department, after which you had seized the vehicle, correct? And the phone.
We seized the phone in the vehicle in Dighton and then followed the tow truck straight to the Canton Police Department.
So at some point, if you had received or gathered the wet clothing at Good Sam, went from Good Sam to Dighton Canton PD, at what point that evening did you finally get those items of clothing out and laid out to dry?
It was late that night, around 10 or so.
So where were the items in the meantime?
They were stored in the back passenger compartment of my pickup truck.
In those double bags?
Correct.
Who took control of the items to then lay them out late that night at the office?
I do not recall.
Is that you or Trooper Proctor?
I don't recall. I don't remember.
At some point, obviously, it was getting late. You'd been on duty for a long time that day. You went home at some point, correct?
At some point, yes.
Did you wait for those clothes to dry before you went home, or did you leave that in Trooper Proctor's hands?
No, once they were laid out in the processing area in the office, we went home.
Okay. Who would have controlled those items of evidence when you left?
Well, they're under lock and key within the secure area of the district attorney's office, so they're secured. Nobody's in physical control watching guard over them.
Who had access to that area?
Troopers in our office.
Meaning you, obviously.
Yes.
Trooper Proctor as well, correct?
Yes. Yes.
Ultimately, given the fact that he was the case officer, sort of in charge, he would have bagged those items up, been responsible for taking those items, tagging them, getting them stored wherever they needed to be stored and processed, correct?
As a case officer, he could direct other people to perform those tasks for him. The evidence officers in the office log in the evidence, and once it was dried, it was sealed up, bagged, and put into storage. As far as who actually performed those tasks, I do not know.
Well, yesterday, Your Honor, may I approach course, right? There's a couple of evidence.
Oh, sure, go ahead.
This is not a vision contest. I'll bring these up to you in just a second, but just for familiarity's sake, do you recognize these two bags as bags that you brought to court with you yesterday?
They look familiar, yes.
Okay. This one has a 437 on it on my right. The one on my left has a 438 on it. May I approach it briefly?
Yes.
I'm not going to ask you to open those. Don't worry about gloving up at this point. The bag on your left, which one is that? 437 or 438?
The bag on my left is 437.
437. Okay. And you indicated that those items were bagged after the clothing was dried and then ultimately processed in, logged in, correct?
Once the items dried, they were bagged and logged in, waiting process, yes.
But you didn't personally do that?
No, I did not, no.
Matter of fact, looking at the bag on your right, what's been marked as exhibit 430, help me? 438, thank you. That one has some writing on it, correct?
Yes, it has a lot of hand writing on it, yes.
And that, whose handwriting is that?
I don't know.
You've seen Trooper Proctor's handwriting 1,000 times, I guess, correct?
Not 1,000 times, but.
Does it look like his writing?
It says Trooper Proctor on it, but other than that, I do not know what Trooper Proctor's handwriting looks like.
All right. It indicates that Trooper Proctor is the one that bagged that item or those items up, correct?
Yes, this bag indicates that the item was collected by Trooper Proctor on 129.
Right.
At 10.
And it says Brockton, correct?
Good Samaritan Hospital in Brockton, yes.
You just took the question out of my mouth. That's where Good Samaritan Hospital is, correct?
That's correct.
And there's a tag or a printed label, looks like a label maker of some sort, that is on that physical bag, correct?
Yes.
Before we get to that, what's the description on that bag in handwriting?
I'm sorry, can you be specific as to description of what, or?
Where it says description of items.
Description of enclosed evidence?
Correct.
It says 1 orange t-shirt, 1 gray long sleeve shirt.
Okay, so may I approach, Your Honor?
Yes.
And before I do that, just so I close this loop, what's the description on the bag to your left, the one that looks like it's less sprinkled?
Number 437?
Yes, if you would read the same clothing description.
The description of enclosed evidence states sweatshirt with recovered items inside container.
Okay. May I approach now?
Yes.
Thank you. Yesterday when you opened, I'll keep my voice up. Yesterday when you opened these two bags, this one, 437, has the gray sweatshirt in it. 438 has the orange t-shirt in it now, correct?
That's what was in the bag, yes.
All right. However, the bag indicates at one point, this bag, 438, the physical bag I'm holding in my left hand, had both the sweatshirt and the t-shirt together, correct?
That's what the description is. I do not know if that was in case or in fact the case.
The reason you don't know is because you're not the one that bagged Trooper Proctor did, correct?
The reason I don't know is I wasn't present during the separation of those items, and I did not observe it taking place, nor was I made aware of how the items were separated or when.
You are aware, however, that tag that's on the label maker looking tag, the white tag that's on that bag indicates that indicates a date of February 4th, correct?
You'd have to bring that back up. I'm
sorry.
I didn't take note of that.
My fault. Mayor, Your Honor?
Yes.
Let's direct your attention to the tag and the date associated with that tag.
The label maker tag does have the date February 4th, 2022 on bag number exhibit 438.
May I approach?
Yes.
Thank you, Sergeant.
Yep.
That's obviously 6 days after the item was actually recovered on the 29th, correct?
Yes, it is.
So that indicates, at least based on that tag, that that item was not booked into evidence and processed until 6 days after it was actually recovered on the floor at Good Samaritan Hospital. Is that right?
The date indicates February 4th, 2022.
Right, and that date would be indicative, in your experience, of the date that it's moved into processing by some other folks, the evidence sergeants or whomever, or the evidence officers rather, or whomever, correct?
I can't speak to their procedures as far as when they print the date. That date could be when they printed the label, but the bag might have been tagged otherwise. I do not know that.
But there's no other tag on that bag that suggests an earlier date, correct?
There's just that one tag from the label maker.
My question to you, if you know, sir, and you may not know, is what was happening to these items between January 29th, after you lost sight of them that night on the butcher paper, and February 4th, when that tag indicates that they were first processed?
To the best of my knowledge, those items were drying on the butcher paper.
For 6 days?
If that's what the label maker says, yes, for 6 days. They were soaking wet.
And those would have been certainly accessible to and in the possession of the lead case officer in the case, was Trooper Proctor, right?
Yes, if Trooper Proctor needed to review those items, he would have access to those items. Absolutely.
And you're also aware that the first actual log of any chain of custody for those items is March 14th, when they were finally submitted 6 weeks later to the crime lab.
That is not true. The first actual log of those items is when we collected them from the hospital.
Where's the log? I'm talking about the physical log, like sign in, sign out log. Where's the log?
It's documented saying that we collected them.
I know that there's a report. Anybody can write a report, right? I can write a report, doesn't mean anything. I'm asking for a log.
Objection.
So the objection sustained.
Obviously, when items move in and out of people's custody in an official capacity for the Massachusetts State Police, there's a log of that, correct?
It's documented, yes.
Or at least it should be, correct?
It's documented.
Where's the log of these items before March 14th?
It's documented in the report.
There is no log, is there, Sergeant?
I do not know.
I want to talk a little bit about some searches that Mr. Lally asked you about, February 4th and February 10th, very specifically. Both of those searches you were involved with out at 34 Fairview, correct?
Correct.
But Sergeant, you didn't personally write a report about your conduct at 34 Fairview on either of those 2 dates. In other words, you didn't go back to the station and generate a report yourself.
I don't recall doing that, no.
There were no photos that you took of the items at the location.
I did.
Else took photos, correct?
I did not take photos of the items.
Okay. And the first report that indicates anything that happened or was recovered at the location on either February 4th or February 10th, that was first notated in a report dated November 4th, 2023, year and several months later, correct?
If you say so, I do not know the exact date. That report would have to be presented to me.
May I approach?
Yes.
You don't have to read the whole thing, but if you can skip to the part that talks about the February 4th and February 10th searches. I'm sorry, I didn't realize you were finished already. What's the date of that? Well, let me ask a foundational question. Does that refresh your recollection as to the date of the report that actually talks about the February 4th and February 10th searches?
It does.
And what's the date of that report, sir?
This report is dated November 4th, 2023.
Thank you. May I approach?
Yes.
Thank you. Now, as it relates to those 2 searches, I'd like to ask you a little bit about the February 4th search first. You indicated that you actually responded to 34 Fairview personally, correct?
I was responding to that location on my own. I personally responded, yes.
Okay. That was because you had received information that Chief Berkowitz had seen something or found something. Is that right? Chief Berkowitz from Canton PD.
That is not correct, no.
Okay. So when you got there, was Chief Berkowitz there?
Yes, he was.
You just happened to go by 34 Fairview at the exact same time on the exact same date as Chief Berkowitz, or was that coordinated in some way?
There was no coordination between me and Chief Berkowitz. As I testified, I had directed the troopers to go by the location. I planned to go by the location in the morning on the way to the office and in the afternoon on the way home, just to see if any more items would reveal themselves. So that morning, I was actually traveling to that location in order to conduct a view of the area to see if any more evidence had been revealed. Prior to my arrival, approximately while I was on Chapman Street, I received a call indicating that Chief Berkowitz was at the location, yes.
And was there also an Officer Lank, Sergeant Lank?
I do not know if Sergeant Lank was there, no.
Okay. Chief Berkowitz certainly was there.
Yes.
And Chief Berkowitz indicated that as he was driving by, he saw a piece of glass.
Yes.
And stopped his car and then started making phone calls.
I believe that's what he indicated to the caller, yes.
Did you question Chief Berkowitz about why he was driving by the location in the first place?
Absolutely not.
Okay. You knew at that point that the Canton Police Department had been recused because of at least an appearance or potential for a conflict of interest, correct?
I knew they recused themselves due to only in respect to interviews. They didn't want to conduct interviews with us side by side.
I mean, if there's a conflict of interest, Sergeant, for a department, conducting the interviews is just one aspect of an investigation, correct?
I'm not going to speak like a conflict of interest, but yes, conducting an interview is just one aspect of the investigation, yes.
So is it your testimony that your understanding was they couldn't conduct interviews, but they could collect evidence, store evidence, write search warrants, get returns on search warrants, execute search warrants, conduct searches. They can do all that, but not conduct interviews.
My understanding was they were recusing themselves from conducting interviews. They still allowed us to use their facilities. We utilized their conference room to conduct interviews. There was evidence being stored at their Sally Port, being the vehicle. So that was my understanding.
Isn't it true that you knew that the entirety of the Canton Police Department had recused itself because of a familiarity between one of their members, Kevin Albert, and the Albert family on whose lawn John O'Keefe was found? That was the conflict, correct?
I knew that that was the connection between them, yes.
And you understood, sir, that that agency was to have nothing, from an investigative standpoint, nothing to do with this investigation, correct?
They were not conducting the investigation, no.
Matter of fact, Trooper Proctor and you supervising him, y'all were conducting the investigation, right?
Our office was conducting the investigation.
So did you find it unusual or suspicious in any way that the chief of police for the conflicted Canton PD was the person driving by 34 Fairview looking for evidence?
Objection.
Can you answer that question, Sergeant?
He would have to repeat it. There's just so much I can't.
It was a little wordy. I'll try it again. Did you find that suspicious?
Which part? You have to repeat the whole thing.
That Chief Berkowitz from the conflicted Canton PD was at 34 Fairview looking for evidence.
The way you posed the question, I did not find it suspicious at all. He's the chief of the police in the town where he works, and he's driving down the street. I mean, that's not suspicious.
With a conflict of interest on the very case that he's driving by.
Objection.
Sustained.
You certainly knew, as a supervisor over the case officer, that any involvement by Canton Police Department, given the fact that there's a potential conflict, any involvement by them could compromise your otherwise clean investigation. You knew that, right?
Not necessarily, no.
Did Chief Berkowitz disclose to you that morning on February 4th that he had been communicating with Brian Higgins and Brian Albert, two witnesses on your case that morning?
Objection.
Sustained.
If you knew information about communication between and among Canton PD and your witnesses, you would find that inappropriate, would you not?
Objection.
Sustained.
You returned to the scene on February 10th, is that right? To conduct another search, you said.
I was present on the 10th, yes.
Who dispatched you back to, or did anybody dispatch you back to that location on February 10th? How did you end up there is a better way to ask it.
February 10th, just like previous days, we made plans to go to the location in the morning, in the afternoon, drive by. I was on my way to work and to home. So I traveled that route on purpose. And as evidence revealed itself due to the natural melting of the snow, we would stop and collect the visible evidence.
You believe at this point, sir, that whatever you might collect at the scene would obviously be important, correct?
Anything we collected that had evidentiary value or presented itself as somehow related to the crime or the incident would be collected.
And it would be important to the investigation, right? You treat it as important.
You treat it as important, yes.
So my question was, especially as it relates to the February 10th search, where there were multiple items found, did you seek to have CSSS come out and actually either mark with GPS coordinates or measure with cross coordinates exactly where each item of evidence was found?
We did not do that. We had collected so much evidence already, and so much has been documented at that point, that we did not contact crime scene services to come back out and photograph more shards of glass and plastic. We simply collected it for processing.
So the location of each one of those items was not of that great importance to you, at least at that time?
It was of great importance as to the fact that it was located in the vicinity where the victim was found and in the vicinity of other items located of the same characteristic, shape, size, and color.
So that's my question, Sergeant. What does vicinity mean?
In the area.
Okay, what does area mean?
It's a location, specific location.
Okay, are we talking about, because we do this all day, I guess, are we talking about an area of 5 feet or an area of 50 feet?
Based on where the items were recovered, we're talking about an area approximately of 30 square feet between the roadway into the grass.
We saw photographs, Sergeant, of items that were butted up against a fire hydrant in one instance, correct? Is that yes?
That's correct, yes.
A drinking straw that's out in the road, correct?
That's correct.
Another shard of glass that's in the grass, closer to the flagpole, correct?
Correct.
A hat that's under the snow, adjacent to the left side of the flagpole, correct? I'm sorry, it wasn't. It was closer to the electrical box, wasn't it?
No, the pictures documented where the hat was. It was to the right of the flagpole.
So these shards of glass, the point I'm asking is, did you seek to use basic cross coordinates, measurements from something that you know is a known object? Like, for instance, I don't know, a flagpole or a fire hydrant. 27 inches to the north and 1.5 feet to the south of those two known points. That would give you a cross coordinate, correct?
It would document the exact location, correct?
And you did not do that with any of these items, correct?
The items that were not photographed were not also GPS located, but they were within the same vicinity of where the other items were collected.
But again, now we're back to the same question. Your word for vicinity might be different than my word for vicinity, right?
Objection.
Sustain.
When you recover these items, or any other items, it's obviously important to memorialize on the evidence bag or in some other way exactly where they're found, who found them, the date, time, etc. Correct?
We do the best we can to document all known information on each evidence item bagged at the time.
And in terms of the February 10th search, I want to just ask you a couple of quick questions about that evidence bag. Did you bag the items into a single evidence bag that you found that day, or do you recall?
I would have to see the bag. If you have those available, I'll take a look. I can answer.
With the court's permission, exhibit, I think it's 310 that was entered into evidence yesterday. I'd like to display that for a second.
Okay.
You're looking at a photograph of what was previously entered into evidence as 310. Can you see that from where you're at? I don't have the evidence bag with me, so if you don't, I can certainly ask the space to enlarge it.
If you can enlarge it, please.
Just a portion of the right. Madam Mayor, approach.
Yes.
I didn't realize I've got a photograph of it.
Do you need the lights on, Sergeant?
Please.
There you go.
Thank you.
Should make it easier. Sergeant, have you been able to familiarize yourself with that evidence bag?
With the photograph, yes.
Okay, thank you. Taking a look at that evidence bag, it has the information on it, has your name is collected by, correct?
Correct.
The date of collection is February 10th, is that right?
That's what it says, yes.
Okay. And it indicates multiple pieces of red, black, and clear plastic, right? It actually says 6 pieces of red, black, and clear plastic, correct?
That's correct.
But that is not an evidence bag that was filled out by
I did not fill that bag out, no.
As a matter of fact, that's Trooper Proctor's handwriting.
I do not know what Trooper Proctor's handwriting is. I cannot confirm that that's his handwriting.
But it's not your handwriting.
It is not my handwriting, no.
So are you aware that this particular bag, that bag that contained those 6 items of plastic material that you already deemed was incredibly important to the investigation, was never brought into any evidence until March 14th, the date that it was submitted to the crime lab?
I was not aware of that, no.
We can take that down, Mr. Bates. If I may approach, Your Honor?
Yes.
Thank you.
You're welcome.
Did you ever draft a report yourself documenting the recovery of those 6 items and the other 14 items that you said that you found on the same date, February 10th?
I did not, no.
Did you leave that assuming that Trooper Proctor would document that?
Objection.
Sustained. Ask it differently.
I'll ask it another way if I can. Did you believe that you didn't need to write a report, Sergeant, because Trooper Proctor would take care of that?
I knew that it would be documented. It was already documented on the actual bag as far as who collected it, when, where, what it was, and a report eventually would be authored on it.
But the where, for all these very intricate pieces, the where is left to 3430 on that, correct?
Objection.
I'll allow it.
Is that right?
The general vicinity location of the other items collected and documented with photographs was consistent with the same locations this was collected.
I want to shift gears for just a second. Well, actually, I want to ask one final question about that item. Based on the documentation that you just mentioned, that it's documented on the bag, and if the bag is presented to the crime lab on on March 14th, some 5 weeks later, those items were completely unaccounted for from a log standpoint the entire time from when they were collected until they were booked at the crime lab, correct?
Objection.
Sustained. Ask it differently.
Possession of those items, of those 4, 5, 6 weeks.
Are you talking about the items that were just displayed on the screen?
I am, sir.
I did not.
Now I'd like to shift gears to a ring video that you saw yesterday. It's in Exhibit 6, video number 153. That may mean nothing to you. It's the 5:07 a.m. video of Ms. Reed's car pulling out of the One Meadows garage. Do you remember that video?
I do.
Okay. You indicated yesterday on questioning, under questioning by Mr. Lally, that Ms. Reed's car came in contact with or close to coming in contact with the other vehicle, the Traverse, in the video. Is that right?
The video, as I watched the video, I observed the vehicle come near Mr. O'Keefe's car.
Okay, that's what I want to talk about. With the court's permission, may we play that video one more time? Basically, pull that up, and then I'm going to ask you to pause it and get out of the way. Okay. You just play that for a quick second, and then I'll ask you to pause it. Pause. Does that appear to be, I'm just pausing it in the first 2 or 3 seconds, does that appear to be the video that you saw yesterday?
It appears that way, yes.
Okay. Mr. Bates, if you could enlarge the area around the left rear tire of the Traverse. I'm going to ask you, sir, if you'll pay close attention to what's been zoomed, and when the SUV gets close to it, I'm going to pause it and ask you another question. You go ahead and play this.
Your Honor, I'm going to object to this.
So why don't we pause the screen, take it down, and I'll see you at sidebar.
Hey guys, all right. We all sometimes get it heated, but let's settle down. If this was an echo chamber, that would be worse than having no fights. So it's okay to have a little bit of battle here. We all sometimes get a little frustrated and say something, but just remember, everybody here is interested in the truth. And so let's appreciate the fact that sometimes we get a little upset or annoyed with each other, because that means we're not an echo chamber. So that's a good thing. But let's try to just dial the temperature down just a little bit. You don't have to go all the way back to zero, because back to zero means there's no room for disagreement, and we don't want that. So, and let's just be careful in how we word things, that we properly put, if we're going to attribute an argument or words to somebody else, let's try to be accurate. So if somebody says something that you disagree with, just if you try to recapture what they say, just please be accurate. And if sometimes somebody comes off a little bit strong or reacts to something, like Jules can be, I've known Jules a while now, and she can react strongly to things. But just live with it. Value her for the other things that she does well. And she always seeks the truth and is coming back in the direction of reason. So either maybe she'll be proved right on something, or maybe you'll be proved right on something, but just don't get upset if she says something a little bit strongly. Just value her for what she is, and that is, she is someone that it can be very passionate. So, Jackson has opened a little bit of a hole here with the chain of custody. Now, maybe it'll be better explained later by Michael Parker.
I'm going to try to situate myself while I'm out of the way. If we could have the lights dim, Your Honor.
Sure.
Go ahead and enlarge the rear area of the traverse. And I'm going to ask you to pay special attention to the back wheel and any movement that you may or may not see. Okay, pause it. Okay, in about the next 3 seconds, Sergeant, I'm asking you to pay special attention to the wheel. Go ahead. We can have the lights on. And you can take that down. Sergeant, were you able to see that video? I know it's not the clearest thing in the world, but were you able to see that video okay?
Yes.
What did you notice about the rear wheel of the Traverse?
Based on the motion in the shot with the snow falling, it appears that there is movement, but the video speaks for itself.
What would you assess based on the movement of the rear wheel of the Traverse about whether or not the two vehicles came in contact with one another?
Objection.
Sustained.
Okay. I have just a moment, Your Honor. Yes. May I inquire?
Yes.
Thank you. I'm trying to use my time wisely, Your Honor. Yesterday, Sergeant, you were asked about a couple of videos related to the Sallyport garage. Do you have that in mind?
Yes.
Matter of fact, we watched one of them pretty specifically toward the end of the day yesterday. Did you actually, I want to talk about the one that is the clearer of the two where you slip. You remember that one?
If you pull it up, I
will in just a second.
Okay.
There was one where Mr. Lally paused it and you were slipping in front of the vehicle.
I don't recall myself slipping, no, but it was icy that day. So if there's documentation of me slipping, I might have.
Fair enough. I didn't mean anything by that other than that was a moment that I thought you might recall to differentiate the videos. It's exhibit 446, but I don't think that's going to help you. All right, let's see if I can do this another way. Did you actually personally go to Canton PD to retrieve any or all of the videos of the Sally Port? You yourself?
I did go to Canton and collect already extracted video.
Okay.
But it was a portion of video surveillance. I didn't collect all of the video, so
When was the most recent time that you went to Canton to collect a portion of the video?
I don't remember.
Okay.
I don't remember. I'm sorry.
Did you review well, let me ask it this way. Did you collect a video that was sought on or about April 23rd, April 24th this year, meaning just a few weeks ago?
Did I collect it?
Correct.
I did not collect that video of April this year, no.
Or you're aware that the video that you saw yesterday was in fact collected after the trial started in April of 2024?
Objection.
Sustained.
Are you aware of when that video that we saw yesterday was collected?
Objection.
Oh.
I am not aware.
Okay. Was yesterday the first time you'd seen that video?
No.
When had you seen that video previously?
A couple of weeks ago.
Okay. What were the circumstances in which you saw that video?
Objection.
Sustained.
Did you have a meeting with the DA?
Objection.
Sustained.
Did you ever have any kind of communication with Mr. Lally about your testimony?
Objection.
Sustained.
May we approach?
Yes.
Okay, this is interesting. This is about the Sally Port video that we saw yesterday that was discussed in one of the last, I think the very last pretrial hearing by David Yannetti, in which Yannetti claimed that the surveillance video was missing. And then to our surprise yesterday, it was not missing. So now it's looking like possibly that was recovered later on. So I don't know why, but it was allowed yesterday. So could this be an early attempt to try to get a mistrial? I don't know. I don't know where this is going to go, but it is actually kind of interesting. For some reason, they didn't have all of that video. And, not everything that happens in life is due to something suspicious. The things that you're going to do today, that I'm going to do today, just part of your routine life as part of your job or just survival at home. If you go over with a microscope later on, there might be things that seem a little bit hard to explain, but now this is not to excuse. You have to get to the bottom here, if possible, and find out, was there anything deliberately withheld from the defense? And I'm not saying that there was or there wasn't, but everything that
you are unmuted
is not necessarily suspicious.
Yes.
Thank you. Sergeant, did you have any meetings or communications with Mr. Lally in anticipation of your testimony?
Yes.
When was that?
It was about 2 weeks ago, and then last week, I believe.
And what was discussed?
Generally, we discussed the portions of the case that I would be presenting.
Did you write a report about your communications with Mr. Lally?
No, I did not.
Were you shown any of the videos that you've seen here in anticipation of your testimony?
Not during the first meeting. I did review a video during the second time.
Okay, and that video was that you did see the second time was the interior video of the Sally Port that we saw yesterday, correct?
I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meeting, so I don't remember exactly what video Mr. Lally showed me.
But you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You have seen that one before?
Yes.
And that was with Mr. Lally, correct?
That is not correct because I do not recall when I saw that video or what video I saw with Mr. Lally.
I see. All right. I'd like to talk about that exhibit 446 for a second, and then I'll show it to you. You indicated that the video all the videos, everything that you saw yesterday was true and accurate, correct? Based on your memory of the events that were memorialized in the video?
The video captures events taking place in an accurate fashion, yes.
In an accurate fashion. All right, that's what I wanted to find out. And after you watched the video, I think you were asked by Mr. Lally, does the video show you or Trooper Proctor having access to or messing with in any way that right rear tail light in any fashion? And you said never.
I was asked if at any point Trooper Proctor and I had came into contact, I believe, or touched the vehicle and that portion of the vehicle, and I said never. We never touched the vehicle prior to it being properly processed with a search warrant.
And that was specifically his question was to, and your answer was to the right rear portion of the vehicle, right? That right rear tail light.
The right rear damaged taillight, correct.
With the court's permission, I'd like to play a portion of Exhibit 446.
Okay.
Before we begin playing it, Mr. Bates, if you wouldn't mind, may I inquire, Your Honor, of the witness, just to lay a foundation? Sergeant, do you recognize this as being the video that we saw yesterday?
It does look accurate.
Okay.
Yes.
I just wanted to make sure we're on the same page. This is 446, just so you have it in mind if I reference that. Space, if you could play that. And I think it's runtime 120. Pause it. Do you recognize that as the video we saw yesterday?
Yes, I do.
Very briefly, if you could move to time of day, 5:37:05. Yes. With the court's permission, can we play at this point?
Yes.
All right, that shows the vehicle coming into the Sally Port, and we're looking at which side of the vehicle?
So that is the driver's side of the vehicle. What that video depicts is a mirror collection. Although mirrors are accurate representation of what you're seeing, it's just inverted. So that is the driver's side of the vehicle. I do not know why it is inverted, but that's the way it was presented, collected and presented from Canton Police.
And you see a timestamp or a time and date stamp on the bottom of that. It's in blue.
I cannot know.
Does it appear that time and date stamp, if you can't read every letter on it, that is in correct order? In other words, that's not inverted.
I cannot read it, no.
All right, let's go and play this for a second. Who is that just got out of the car?
I do not know. I think that's the tow truck driver. He would have the only access to the vehicle. We did not touch the vehicle.
Who's that on the left?
I missed that. I was looking down at the laser pointer. I do not know. I know for a fact I'm the gentleman that's wearing a dark olive drab state police baseball style hat, and Trooper Mike Proctor is wearing a winter hat.
Trooper Proctor's wearing what?
A winter hat.
That was playing, and I didn't realize it was playing while you were talking. Stop. Look for that. And stop. Yesterday, when you testified, you indicated that the two individuals in this scene were you and Trooper Proctor, correct?
That is not correct. There was two individuals in the rear of the vehicle I shined my light to. That was me and Trooper Proctor.
Do you see Trooper Proctor toward the back of the rear vehicle there?
I can't tell because of what the head is. I just know that Trooper Proctor was wearing a black hat.
Which the person in that in the video to the left, to the rear of the car, is wearing a black hat, correct?
I can't tell. I don't want to be locked into a statement where later on you show me that it's somebody else magically. I can't testify to that.
There's no magic about this. It's your testimony. I'm just asking you what you see.
I don't see that. No.
Stop. Let's go ahead and play it this way. You see the person toward the back of the vehicle walking toward the opposite side of the SUV?
I do.
What area does he appear to be going to?
He appears to be going towards the rear passenger side of the vehicle, although it does not appear so because the video is inverted, a mirror image. That's where he's going.
And Sergeant Buchnick, you testified for at least a half an hour about this video yesterday, correct?
I'm sorry, it was a long day. I don't know the timing of how long I testified.
You significantly testified about this video yesterday, did you not?
I testified about this video.
And you testified that it was true and accurate, correct?
Correct.
You testified that it was reflective of your observations of what was happening in that Sally Port that evening, correct?
I testified that this is a accurate scene and collection of video evidence from the Sally Port.
And as that truck sits in that Sally Port, just like this, it appears from all perspectives that what we're looking at is the passenger side of the car, and that right rear taillight is right there shining in our face, correct? From this perspective.
I'm sorry, can you repeat the question?
From this perspective, from the perspective that the jurors are looking at,
okay.
From all indications, that would appear to be the right side of the truck, the passenger side of the truck, and that taillight that you can see is the right rear taillight from this perspective, correct?
The way it presents itself, yes.
And yesterday, during the entirety of your questioning by Mr. Lally, not once did you mention that this video is actually completely inverted, correct?
I did not know.
Mr. Lally didn't ask you if it was inverted, correct?
That's correct.
And if I hadn't gotten up here and begun questioning you, that would be left uncorrected, correct?
Objection. Sustained.
The person with the winter cap appears to walk directly to the what ultimately should be the right rear tail light of this car, correct?
That's the vicinity, yes. That's where he is. Yeah.
Pause it. I'd like you to pay attention to the right rear of this car. And I know we're completely backward, but it's the far corner of the car. Do you see a person's head there?
It appears as if someone's still there.
And that person is located at or near what portion of the car?
In real life or as it's depicted?
Is the person near in real life, near the right rear tail light of the car?
Yes.
Matter of fact, standing there, hovering around there, correct?
We don't know the distance that they are in proximity to the actual vehicle. We just know that they're behind the vehicle. That
looks like it's pretty close, doesn't it, Sergeant?
Objection.
Sustained.
Does that look like he's in close proximity to the right rear tail light?
As I said, I can't tell how far away he is from the vehicle.
His head's right there, sir. You can't tell that he's right next to the right rear tail light?
Objection.
Sustained.
All right. I want you to pay attention to what that person does as soon as the other person comes out from behind that car. So you see him moving. Stop it. Do you see that person move?
I saw movement in the frame, yes.
Right when the other person is in eyesight of the person toward the right rear, correct?
I mean, the video speaks for itself.
Yeah, it does.
No.
Objection, Your Honor.
The objection sustained. No commenting, Mr. Jackson. We've talked about that.
I'm going to ask Mr. Bates to back it up because there's one other issue I want you to pay attention to, if you can, right at this moment or right before this moment, and that is the timestamp. We back it up in maybe 10 seconds. Right about there. Don't play it yet. Instead of paying attention to the individuals, I'm going to ask you, can you see, may I approach the screen here? Yes. Can you see the timestamp at 5:37 and 37 seconds p.m.? Can you see that from where you're at?
No, I cannot.
Me neither. That's why I had to walk up to it. Let's play it for about 10 seconds. Pause it. Did you see another person just appear toward the rear end of the car?
There was a fog of some sorts. It did appear as if a person was actually in. There was two people back there, and two people walked away, or one person walked away.
The timestamp jumped to 5:38:01. Correct?
I cannot see the timestamp, sir.
Did it appear that there was an anomaly? There was a portion of that video that was deleted. Or it's missing, not deleted, but just missing.
Objection.
Can you tell that? Does it appear that way to you, Sergeant?
No, Your Honor, I cannot tell what is happening with the video.
If you take a close look at there's a classic police car in that Sally Port, correct?
There's an antique vehicle there, yes.
If you take a close look at the trunk of that vehicle, see the word police?
Yes, I believe I can read that, yes.
And it's backward, correct?
It is mirrored, correct.
That's a good indication that this is an inverted video, right?
It appears that way, yes.
And if we were to fast forward at 5:42, Not another 20 seconds. There you go. Can we just play it at this point? No. You take one pause it. Pause it. You see the Sallyport garage came down?
Yes,
You see a number on the garage?
I do.
Is that correct?
What is correct?
Does the number appear correct? How do you make it 4?
No, the number's in the mirror image, yes.
I just wanted to make the point. Everything in this video is completely correct?
It's not backwards, it's mirrored, reversed. You can look yourself in the mirror in the morning, you still see your own face. It's not backwards.
But my mirror image is not an accurate depiction of who I am. My actual physical appearance is who I am, correct?
Objection.
Sustained.
A mirror image, Sergeant, is not an accurate video of this, is it?
Objection.
It's a mirror image by definition.
Sustained. Ask it differently, Mr. Jackson.
Your Honor, thank you. I don't think so. I would like to mark I have a, we can bring the lights up. Let's
Wait.
I have a thumb drive that I'd like to have marked with the court's permission.
Does Mr. Lally know what's on this thumb drive without you telling us?
I do not.
Okay.
We can approach and I can certainly bring it up.
We're trying to wrap up our morning. It's marked for identification.
If I may, Your Honor, I'd like to play the first 10 seconds of that video.
No. We'll come to something. It's marked for identification, right, Mr. Jackson?
You are.
Hey guys, good morning. So we know they're going to close this today at 12, and that'll be the end of testimony. And then there's no testimony, there's no court tomorrow, so we'll have to wait until next Monday. There's a lot of big stuff coming next week, including the real technical stuff from the cars people. That's the state police guys who explain all this stuff, and we're going to hear finally from the medical examiners, from Trooper Proctor, from the explanation of the accident. And again, I don't want to be repetitive to what I said before, but let's try to value each other for our differences. I don't mean this in kind of some ABC after school special, overly cheerful way. I just mean we don't want to be an echo chamber, so it's good that we all have questions. As far as the chain of evidence, it's not fully explained yet. It's not fully documented. So how big of a problem it is now, so there's been many things in this case that were put out by the defense as big deals, and then they were eventually explained, including the idea of Higgins destroying his SIM card and destroying his phone at a military base. That sounded really, really suspicious, right? But it wasn't at all, because he lives in Brewster, Mass, where there's no town garbage pickup, and you drop your bags off every day. In fact, Tom Fleming, our moderator here, his mom lives there, and so I've seen this firsthand. She drives the garbage bags to the Brewster recycling service. That's basically where they drop off their trash, but they have to pay for that. So in Higgins' case, he's driving every day across the military base on his way back into the state to go to his other home or his job. And it's a natural thing to just every day he's going to take a couple of bags of garbage and just throw them out at the base in one of the dumpsters or something like that. So it's not at all suspicious. Now, you might find it suspicious that he happened to upgrade his phone on the 29th, but that's a separate subject. But the idea that Higgins went to a military base, it sounds all nefarious, but it wasn't. There's no missing belt. There's no missing hat, right? And, how important is that? If John was killed inside the house, I don't know. Was the hat just taken and dumped there just the way it was? I mean, I think a lot of this stuff is... If they were going to dump the hat if they deposited John on the lawn and they dumped the hat there, wouldn't the hat be found right with John? Wouldn't they take the hat? Like, you're going to take John's body and you're going to drop him there on the lawn on top of his cell phone, wouldn't you just drop the hat right there with him? Another thing was the black straw. The black straw, we saw the image of, was actually found in the street. So that's why it wasn't found till the later search. But if they were going to take that black straw with the remnants of the cocktail glass from inside the house, and I always found it strange that the conspirators would go to the distance of actually leaving the black straw, taking that out too, that seemed very unlikely to me. But now it's super unlikely, because would you take that black straw? Wouldn't you just drop it next to John with the bottom of the cocktail glass? Why would you drop it at a different location? So a lot of this stuff just really doesn't add up as a conspiracy theory. But that doesn't mean there aren't things that we need to know. We do need to know, where John's clothing was. Now, it was understandable that it couldn't just be left in an evidence bag because it was soaking wet. It had to be left out to dry. And we know that it was left out to dry for 6 days. That actually doesn't strike me as unreasonable to let that dry out. But then, according to the defense, it's not logged in until the 14th. So what happened, though, after that 6 days? Something happened that we know that it was bagged. I presumably that must be when the date is on the tape that it was bagged. So where did it go from there? I mean, maybe it just was with the other evidence at the DA's office. I think that seems likely. And so technically, from that time until the 14th of March, I would guess, and we'll see this explained later, that Michael Proctor would have had access to it. However, it was taped. So every time it was sealed and taped, as we saw that process that Yuri went through in court yesterday. So, is Michael Proctor hanging around in with the evidence in that room, in the DA's office? Is he opening that bag and then resealing it? There should be a record of that, Thank you, Tom. You don't have to do that, brother. I owe you enough beers already. So, I mean, but these things do have to be fully explained as best as possible. And that doesn't mean that everything... I don't know why you keep saying that, Jason. Proctor is testifying next week. You don't believe me? Fine. I'm not going to keep repeating it. Proctor is testifying next week. Okay, I guess Turtle Boy must have said something. And if you want to take Turtle Boy's word over mine, okay, that's your choice. But Proctor is testifying next week. So, not everything in a case is going to be perfectly explained. These are a bunch of human beings that have other things going on in their lives. They have other cases that they're working on. There's multiple people working on these things at the same time. As we saw from that day, things were disrupted by the blizzard. So there's no such thing as a perfect investigation. If there was a perfect investigation, a good defense team will still find things to make it look suspicious. And you got to keep that in mind. I think just people have to, maybe people have seen movies and it's always the defense team that's the good guys proving the client, I guess, proving the client is innocent. But in the real world, while there are too many innocent people that are in jail, but the majority of crimes, the majority of trials involve people that are guilty. Now, we can haggle over that number. Is it 80%? Is it 95%? I don't know. But the majority of people that are brought before a jury are actually guilty. But in every one of those cases, the defense team is going to find, and as they're supposed to, but find every little oddity to say, aha. Now, we and the public have to understand that that's their job, but that's what's going on.
You are unmuted.
Kenneth, we're gonna have you come back on Monday.
I can.
So we'll just wait. Jurors, I know that you want to know when this case is gonna end, and I don't mean that in any negative way. After speaking with the lawyers, I can safely say that you will get this case for your deliberations sometime the last week in June. We'll know better next week. We will not be in session next Tuesday. We will go full days, Monday, Wednesday, Thursday, Friday next week. We will not be in session next Tuesday. I have to give you those cautions again. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Great weekend. We'll see you later.
All rise for the jury, please, jurors.
You are muted.
Thank you.
You may be seated.
All right, so I received a motion from the Commonwealth this morning that I have not had an opportunity to read yet. It's on my desk. I'd like to go spend a few minutes looking at that and come back out at 12 o'clock on that.
In order for us to argue it?
Yes. Do you need?
I didn't get it either.
Okay.
We've been busy.
All right.
Could we do it on Monday?
I want to get as much evidence in as we can each day. We can do it at 8:30 Monday morning, I think. Madam Court Reporter, can we do it at 8:30? Yeah. Jim?
Sure. Absolutely fine with us. Not that it matters. But we can.
Can we do it at 8:30 Monday morning?
If that's what the court wants, yes.
Yeah, we'll have a hearing on it at 8:30 Monday. Are you around tomorrow? Are you around tomorrow?
Oh, am I? Yes, absolutely.
Do you want to do it tomorrow morning?
If I had a preference, I would say Monday.
All right, we'll do Monday morning at 8:30.
I'm sorry, well, Monday.
Okay,
And if you want to put something in writing, just email it to us this weekend.
will do.
Okay.
Thank you.
All right, we'll see you then.
All rise for the court, please.
All bow to the wisdom of the ceiling fan.
Hey there, Karen Reed, trial watchers. This is a law and crime legal alert. Google Incognito.
All right, so we may be back briefly tomorrow morning. There is, no, I'm sorry, Monday. I'm sorry. They decided to go on Monday. So Monday morning, we'll be here early, I guess. If this is televised, there'll be a motion. Anybody have any ideas what this new motion by the state is going to be? I'm going to read. I'm looking in comments because I have no idea. So I'm looking to see what this new motion could, if anybody has any ideas. If anybody wants to speculate what this new motion will be. It won't be a motion to dismiss by the state, so no. Won't be that, Maui. I'm just looking to see if anybody has any ideas. So if I get any hints from anybody of my sources, I will, if I can report it, I will report it. I guess I'll do it on Twitter. Or actually tonight. So last night was the first we did of our 20-minute recaps that we're going to do for every day where there's a trial. So we'll be back tonight, me and Tom Fleming, and if Dave McGrath, if health is permitting it. And so we'll be back at about 7:15, between 7 and 7:15. And the idea is to do a 20-minute recap of the important parts of the day, objectively, all the important elements, including things that might be helpful to the defense. So we don't want to do it in a one-sided kind of way, but the idea is that we can get this done in a 20-minute way so that if you missed the trial and you want to go back and just get the bullet points, we'll do it for you. So that's what we're trying to do. I have not found anybody else doing that. Else would do it, so we wouldn't have to, because I just don't have a lot of time, and I don't have time to do it presented in an effective way, like, for instance, adding a lot of clips and images and video. We're trying, so if anybody wants to send us clips, we did get some yesterday, but the more the better. So if anybody captures any key moments, short clips from the day, send it to me, and we'll show it during the show. These are just important moments of the time for the trial, anything at all. Please send it to me. You can email it at leitskev, LEITSKEV @gmail.com. And thank you, Sailboat. You're always a great supporter, and it's much appreciated. Since you're giving the money, Sailboat, I want to take a moment to talk about what I'm doing with the money, because I never ask for money, and I don't need money for lunch. There are expenses with the channel, but they amount to about $100 a month. You got to pay StreamYard and different things like that. So over the last few months, it's taking in more than that. Nothing like turtle money, but it's taking in a little bit more than that. But I also kind of know that after the Karen Reed trial, that'll probably dry up to way less than the $100 a month. So to some degree, I just take that and say, all right, let's bank this, and this will keep the channel going for another year. But one thing that I want to do with that, some of that money, if I can pile it up, is get another turtle. People will love this. Another animation made. So I've actually contracted for a couple, and one of them is a new animation that we'll use. That's a variation of the one I did before, but that shows what seems to be the state's theory, the current theory of the accident. So, and thank you, EC, appreciate it. So I've contracted with the same person who made the other one to make this one. Hopefully it'll be out tomorrow. And in addition, I've contracted with him to make a video related to the Delphi murders. Nothing that would show anything related to the murders, not that kind of thing, but just to show where people are. Thank you, Scott. Appreciate it. So with that one, that's going to be a little bit more involved video, but in the Delphi murders, and this is really one that has infinitely more global interest than the Karen Reed case. And that trial was actually scheduled for May, so we would be in the middle of it, but it was postponed now until October. So that trial will be in October. But another fascinating, really horrible case. But there's interesting evidence in Richard Allen's own words, who's on trial for it, and in the words of the witnesses that put him at certain locations on the Monon High Bridge Trail in Delphi. So I've contracted to make a longer video on that, and I think that's something that that we can work on. Is my cam backwards? It's in reverse. Can you tell? No. So all right. So what do we get? So all right. So another interesting thing. So we just found out the judge just promised the jury that they will have this in their hands to deliberate on the last week of June. So we started the first week, right? So that would put it at what? 9 weeks, I guess. So that means they were off in their estimates by, I think the original estimates were that they thought this trial was going to go 6 to 8 weeks, right? Or was it 7 to 9 weeks? So maybe they're a week off. What question? I missed the question. TJB, what's the question you want me to ask Kevin Mahoney? I'd be happy to get it to him. And Kevin's busy involved in a trial right now, so he's not able to see what's going on during the day. But he gets caught up from his own sources, and I talk to him also, and so we let him know what's going on. But obviously he's very interested in this case. His first excellent article on it came out in September, and he's done several articles since then. And he's been a guest on the show a couple of times. He's been on Court TV, and he has a lot of other interests outside of the law. So he's a very interesting guy. So just trying to see if I missed the question that he or she had. TJB, ask the attorney. I'm looking. So feel free to, I'm trying to watch for your answer here for the question you want me to ask him, but feel free to email me that at leitskev @gmail.com. Leits, so that's LEITSKEV @gmail.com. I set up that email back when I owned a bar in Worcester called Leitham's Pub. And so that's where the name comes from. People have asked me if it's like Russian or something like that. No, Leitrim is actually a county in Ireland. I did not give the pub its name because the pub has been there since the 70s. So, is Kevin as well as Yannetti as far as attorney ratings? I couldn't answer that. I have no idea, but I don't even know there were attorney ratings. But I think, well, depending on how this trials goes, that should really have an impact on Yannetti's reputation, right? And there are other lawyers out there that have told me they believe there will be disciplinary action against Yannetti as a result of this case. Significant action from the Boston Bar Association, and that is all related to Turtle Boy. It's a violation of certain rules. As far as Joe Krowski, I talk to Joe by text every day during the trial. He messages me to see what's going on because he's busy in court too. He's actually locked up in a case the next 2 weeks too. But yeah, Joe is the delusion here from Kevin. I don't have any delusions, but yeah, Joe's just a great orator, great storyteller. He has promised to come on the show, but what these guys, when they're involved in a trial, you can see how much work goes into this. Just even watching this case, Lally's going to be working 100 hours a week. So both Mahoney in separate trials and Joe Krowski are in the middle of cases, and that means pretty much 7 days a week, 7 nights a week working on that. That's how it goes. And then they have a little downtime. So when he has downtime, he is going to come on the show. I assume I'll be doing Court TV tonight, Comfort and Joy. They always have me and Nick and one of the attorneys on whenever there's a day of a trial. So Proctor is okay. So we'll take this as a fair question, Jason. Serious question. I know you totally disagree. If Proctor is told both sides that he is pleading the fifth, can you ask a lawyer if they forced him on the stand, or can Bev say no? I don't know. We saw Mark Furman in the OJ case on the stand, pled the fifth for one question. And that was when they asked him, the defense asked him, had he ever planted evidence in another case? And he pled the fifth. And that may have been the difference in that case. So I don't know, but he didn't plead the fifth. But Michael Proctor is testifying next week, and he is absolutely not pleading the fifth on any issue. There's no evidence anywhere that Michael Proctor has ever committed a crime, certainly related to this case. Okay, you can't just, this is hype that is put up by a machine. Now, the defense is claiming that Proctor was compromised because his sister is friends with Chris Albert's wife and Chris Albert's wife's sister. Is that the basis? Could that somehow plausibly form the motive for planting evidence in a murder case? To me, that's insane. But I have to say this. My approach has always been, when it comes to motive, is that sometimes you don't know motive, right? So let's just say hypothetically, you get involved in some kind of a case and you need your local police officer to help fix it for you, but it's a murder case or something significant. So this cop has to take on a tremendous risk. He's not only going to get fired, he's going to go to jail. And if it's a homicide case, go to jail for a very long time. So what motive would be sufficient to cause that cop to plant evidence in that kind of a case and take on that kind of a risk? Well, because it would have to be a mighty powerful motive, right? But you can't just dismiss, when you're looking at the evidence, the possibility of a motive, because there could be some motive that someone doesn't know. So for instance, let's say that the person who needs help from that cop has the kind of dirt on that cop that could be used to destroy him, something really, really, really bad. So when you're looking at this, just because you can't initially find a motive doesn't mean you should automatically dismiss the idea that a police officer might be corrupt. But you'd certainly have to keep in the back of your mind that the lack of motive sufficient to cause someone to take on that risk is a big deal. And if you're listening to a journalist or anyone that is trying to suggest that the fact that Michael Proctor's sister knows Chris Albert's wife and Chris Albert wasn't in the house, if you think that that's sufficient motive for Michael Proctor to risk the life of his family and risk his own freedom to participate in a cover-up, no, you need to, I'm sorry, I don't mean to be, you need to have your head examined. That's not enough motive. So that doesn't mean that we can completely say, oh, Michael Proctor didn't have motive, because there could have been some motive that we aren't aware of. But if you're basing the motive on that defense theory there, you need to have your head examined. I guarantee you, Alan Jackson does not believe that Michael Proctor had motive based on the relationship between his sister and the Alberts. Alan Jackson does not believe that there's motive for Michael Proctor to participate in a murder cover-up. But that's not his job. He's a defense lawyer, and his job is to spin things that people in the public and hopefully the jury will believe. So, but for me, I had concluded that there was no conspiracy here simply because there was so many things stacked up that multiply against each other that made it unlikely, starting with the opportunity. There was just really almost no access to Karen's SUV within the time frame that allowed for someone to go to the crime scene and bury that evidence in the snow. And I've proved accurate on that. I said that that the CERT team, we knew that they had reported that they found the police at 5. They found the first taillight piece at 5:45, the main piece, at 5:45 p.m. Okay, so we knew that Karen's vehicle was towed from 418. And on a normal day, it's a 45-minute drive, 50-minute drive to Canton. This was during a blizzard. So we knew that that vehicle arrived sometime after 5. Now, Nick Rocco kept falsely stating that it was 5:08. He's been saying that for months on court TV or for weeks. I'm not saying he's lying. I think he's been misled by Karen. Go figure, right? There's a lot of that. But we now know that that vehicle arrived outside the Sally Port at 5:31 and went into the Sally Port at 5:36. And we also now know from Lieutenant O'Hara that he arrived before 5. There were 2 state troopers from the CERT team there before 5, and that the last member of the CERT team to arrive was at 5:41. They started looking before that, but in 5:41 they started in earnest to methodically go through the crime scene. So there was no time for someone to pry pieces from the taillight in the Sally Port, go to the crime scene, and bury it in front of those other troopers. This is an impossibility. This is not just that's actually an impossibility unless all of the CERT team was in on it. And you saw Lieutenant O'Hara testify. So again, if you need everybody to be involved in this conspiracy, at some point, it's just a crazy dream, right? It's so incredibly unlikely that it makes no sense. So, and this is what happens with this conspiracy. You need Morrissey to lie about Michael Proctor not going to 34 that day. You need Yuri Buchanan to lie about it. You need all the CERT team troops to lie about it. There were 7 people on the CERT team there. There were 2 other troopers that were there observing. There were 3 Canton cops there. All of them have to be aware that this is a murder cover-up. You need to have the medical examiners covering up the fact that John was beat up and attacked by a dog. And just all of this, each one of these things might not be completely impossible. So let's say what is the odds that there was a dog attack? Sorry, I just answering court TV. Hold on a second. Yes, I am available. All right. What are the odds that there was a vicious attack by a German Shepherd on John O'Keefe, a large dog, a large German Shepherd attacked John O'Keefe violently because it was a fight. It wasn't, John O'Keefe wasn't over there playing fetch with Chloe. And that a medical examiner is not going to discover any evidence of that. What are the odds of that? How would you guys lay it? Would you say that's 1 in 100 that she wouldn't find that? And there were 2 medical examiners, but would you say there was 1 in 100 that they wouldn't find that? Is it 1 in 1,000? 1 in 10,000? Let's go with 1 in 100, being super, super conservative. Let's go with 1 in 100. So there's a 1 in 100 chance that John was attacked by a dog and the medical examiners either were corrupted and they're part of the conspiracy, or they somehow were incompetent and couldn't tell that that was the result of a dog attack. Then in addition to that, you have the odds that no canine DNA will be found on John's clothing. What are the odds of that? Again, I'd say 1 in many thousands, but let's be conservative and say 1 in 100. That's crazy conservative, but I'm saying that to please the zombies. That's as far as I'll go. So you have a 1 in 100 chance that the medical examiners are either in on this or didn't somehow detect the attack, and a 1 in 100 chance that no canine DNA was detected. Well, this is, like I've said many times before, the way odds work is like this. So if the Patriots have a 1 in 100 chance, let's be kinder to the Patriots. Let's say the Patriots have a 1 in 10 chance of winning the Super Bowl next year. That's kind of a pipe dream too, but let's say a 1 in 10. No, yeah, let's go with 100. Let's say the Patriots have a 1 in 100 chance of winning the Super Bowl next year, and the Bruins have a 1 in 1. Well, we'll give the Bruins a 1 in 10 chance. The Bruins have a 1 in 10 chance of winning the Stanley Cup. What are the odds that the Bruins win the Stanley Cup and the Patriots win the Super Bowl in the same year? Well, it's 10 times 100, right? So that's 1,000. Just to see how it works. That's the way odds work. They multiply together. So going back to the dog attack issue. So we're being super conservative here and saying there's a 1 in 100 chance that the medical examiners were either in on it or couldn't tell that John was attacked by a dog, and a 1 in 100 chance that the canine swabs that were done all around the right clothing, as you saw the criminologist Ashley Valet demonstrate, or it might have been the other one, but you saw them demonstrate. Again, so a 1 in 100 chance on that too. So now you have 100 times 100. And there's your odds. That's your odds just on the attack, that whether John was attacked by a dog. So what is that? 10,000? 1 in 10,000. So there's a 1 in 10,000 chance, based on those super conservative odds, that John was attacked by a dog. And there's so many aspects of this case that you could just multiply that together. What are the odds that 11 people in the house all stayed silent and have stayed silent through a federal investigation? What are the odds against that? It's got to be at least a 1 in 1,000, right? So, if you were witness to a violent murder inside a house, and everybody inside the house convinced you to be quiet about it, you're living in fear that that's going to be discovered and you're going to go to jail for a very long time as an accomplice to murder. All right, you're living in terror with that, but somehow you hold it together. But one of your fears is that somebody else inside that house is going to flip. And so if you're afraid of that, the only way to really save your own skin is to you flip first. And then you find out that the feds are onto you. They're onto the whole conspiracy. The FBI is investigating it. If that happens, the pressure on you to run to the DA's office and cut a deal is enormous. What are the chances that you would resist that pressure? Again, let's be conservative here and say, I'll be super crazy conservative and say 1 in 100 again. So now we can look at the odds of the dog attack, which we now know what I just established as 1 in 10,000, matched up with the super conservative odds against everybody staying quiet in the house through the federal investigation, which I'm being super conservative and saying is 1 in 100. So you multiply that. Now you got 100 times 10,000. And I believe that's 1 million. Somebody check my math on that. I believe 100 times 10,000 is 1 million. But I haven't had that second cup of coffee, so I could be off. So you're already at, just on those pieces of simple odds there, those simple matters, you're up to 1 in 1 million. And there's other aspects of this. What are the odds that people are going to kill some guy or beat him to within an inch of death inside the house and then drop that person off on their own lawn? What are the odds of that? Drop that person still alive on their lawn. Telling everybody that's leaving the house that the plan is to let him die in the cold, risking that he might survive and tell the police what happened. Is that sensible? What are the odds of that? To me, it's extremely long. What are the odds that Brian Albert inside the house, a veteran cop, is going to even think that the medical examiners are not going to be able to look at John's body and see that he was attacked by a dog and beat up? What are the odds of that? I mean, it's foolish. He's a very intelligent, very experienced cop. He knows they're not going to get away with that. He knows it. So unless he can somehow control which medical examiners are assigned to that case, and he knows that he can control those medical examiners and co-opt them into the conspiracy, then he's not going to do that. It's just on and on it goes. There's so many aspects of this conspiracy that make no sense to any sane person. They just don't. Now, that doesn't mean there aren't legitimate questions about the case. There are odd things in every case. In every case, there's no such thing as a perfect investigation. And even if there was a perfect investigation, there would still things that look from the outside odd, especially when they're cast in a certain way by the defense team. But odd things don't add up to reasonable doubt by themselves. It depends on how solid the other evidence is. Again, there are odd things in 100% of cases. 100%. Yes, I just got a message saying Proctor will be testifying for the prosecution, but I know, yes. Thanks. That's from my mother, who doesn't usually listen to my show. So she thinks I'm too angry and have too much of a temper. But yes, Proctor is testifying absolutely for the prosecution next week. And so that'll be a very interesting day. But back to the odd things, and then we'll wrap this up soon. In 100% of any large-scale, solid-scale investigation, in 100% of those cases, you can find odd things. You can find some things that are never even explained because human behavior is complex and these things involve a lot of people. That doesn't mean you dismiss odd things. Odd things are important because odd things can be meaningful. What you have to do is decide whether they're meaningful or whether they're not meaningful. That's what a jury's going to have to decide. That's what a jury always has to decide because those odd things are in every case. So what they have to do is, and what you have to do is look at all of the foundational evidence and the logic so when I'm talking about the odds of a canine attack, that's logic. That's logic applied to the evidence and to the circumstances. So if that stuff is not solid, then you turn to the odd things and see maybe they might reveal something. Sorry, I get messages, and if I seem like I'm having a brain fart, that's usually because you can always hear my phone going off, so it's always some kind of message. I'm not even sure who this is from. I guess it's just a schedule for the rest of the trial. Okay. So what you have to do is, to the extent that the foundational evidence is tight and adds up, to the extent that it is, then you have to dismiss the odd things as just things that happen in every case. And you can't dwell on them. And this is what happened. But in the public, people dwell on these odd things. Now, we've already seen almost everything that was sent to us over the last year as being odd. 95% of it's been dismissed already in trial. So we were told as late as yesterday that John's cap, baseball cap, was not found. Well, we saw a picture of it today. It was found. We were told, and for months people have been saying that, right? And we've been told for months, for a year, that John's belt is missing. Melanie Little, who we think probably works directly for Karen, has been obsessed with the missing belt. Well, the belt is in the evidence bag. All right, so there's no missing belt. Nick told us that the presence of a comma where he thought it shouldn't be inside the messages between Colin and Allie was evidence that those messages were edited and manufactured. That was not true, and we've actually seen other. So, for instance, looking at Higgins' messages that were shown on the screen, the comma's in the exactly same spot. So that was just a bunch of baloney. Now, Nick doesn't invent this stuff on his mind on his own. This stuff is given to him by Karen Reed and by her inner circle, and then it's spread out through social media. But in almost every case, it turns out to be eventually refuted. It's been and much of this stuff is refuted in this case, almost all of it so far. So all the big things that they believe in, the idea that there was missing video that didn't show John's SUV being brought into the Sally Port. Well, we just saw that yesterday. That wasn't true, and that wasn't just put out in social media. David Yannetti said that in court. And if that surveillance video had been improperly withheld and turned over at the last second, the defense would have filed a motion for a mistrial. They have not. So one by one, everything that is presented to us in the public turns out to be misinformation. But why are we surprised by this? Why is anybody surprised by this? That's what I want to know. Do we not really understand how a defense team really works, what their job is? Isn't it their job to go and find out and try to cast everything in a suspicious light, whether it's non-human hairs or missing or gaps in library videos? Doesn't our common sense tell us that that's what a defense team is going to do in every case? We're seeing this in other big cases like Richard Allen in Delphi, where they've gone with that they're defending their client by saying he was completely innocent because the girls were killed by an Odinist cult. Their client wasn't even there. All right. This goes on in every case, but why don't we have, do we in the public have no understanding at all about how a trial works? Why are we caught surprised by this? And I mean, because I guess a lot of very intelligent and decent people are caught by surprise by this stuff. I guess too many people in the public, I guess it's the CSI effect. We think that a trial is something that's going to take place in an hour and everything is going to be neatly wrapped up. And the defense team is always going to be super honest. And it's the prosecution that's shady, like in A Few Good Men, which is one of my top movies. I mean, I watch that every time it comes on. I'd say it's a top 5 movie for me. Maybe even number 1. I mean, I love A Few Good Men. But this is how it often is in a movie. It's the defendant is the underdog. The defendant is someone that's falsely accused, and it looks really bad. And so you have to have a defendant that, against all odds, manages to prove that their client was innocent. That makes for a great movie. But it's not reality. And people should have enough understanding of how trials really work to understand that this is what a defense team is going to do. They're going to take every little thing and throw it out there. Like you talked about Higgins throwing out his trash on the military base. I mean, one by one, everything in this case has been dismissed. Everything. Like, I don't really understand. I can understand people that aren't following the case closely and they're just seeing what's reported maybe a little bit in social media or by the grifting channels or by the grifting Boston Herald. I've been a Boston Herald subscriber all my life. And so I'm very disappointed at the way they falsely present what's going on in this trial. To some degree, Court TV too. I hate to be honest about it. On some of the channels, on some of the shows, it's troubling. But we in the public have to understand that that's how it works. That everybody's trying to everybody's trying to get clicks and views, whether you're Turtle Boy or Sean or the Jellyfish or Court TV or the New York Post or the Boston Herald. There is a lot of pressure to get clicks and views. And in some of these cases, I mean, the Herald is about 6 pages deep now. So it's very difficult to survive in that industry now. So there's enormous pressure on them, and they're willing to sacrifice the truth. Unfortunately. I talked to a while yesterday to the great reporter Gretchen Voss, and she's very disheartened by what she's seeing. I'm not going to put words in her mouth, so hopefully someday she'll come on here, or you can read her next article wherever it comes out. But she believes in an old school type of journalism where you get the story and you get it right and you get to the truth and you find what's the important part of the story. Okay. And the rest, you don't worry about views. You don't worry about what the value of it is. You get the story, get it right, and you hope that you can make a living doing it. That enough people trust your source and want the truth that they'll consider your reporting valuable. But it's disheartening to see how many mainstream media sources no longer want to do that. I don't really know of any source that I trust anymore. Some sources might be covering this particular case okay, but they may not cover other things fairly, especially if there's anything political involved, any kind of ideology. For me, I've always been interested in politics. I have a mix of conservative and liberal values. I really just care about the truth. And I kind of understand that almost all the news sources have an axe to grind one way or the other. But what's gotten worse over the last 10 years is the way they deliberately distort the truth. It bothers me. It's one thing to just not recognize your own biases or maybe play a little bit to your particular audience. But what I watch on ABC News, for instance, over the last 5, 6, 8 years, disgusts me. I don't feel like they even have an interest. It's not just that they don't have an interest in the truth. They are willing to misinform the public. It's everybody has an agenda. Everybody, and it's political and it's ideological. And they feel the ends justify the means. So they just want to help their side. And they don't care. And they're willing to sacrifice truth on the altar of that ideology. And I don't know how to fix it, because you don't want to have, the only way to fix it is to have the public care about the truth. And that's it. And it's the public to try to look at every case or every situation politically or whatever, try to see things from both sides and to try to get to the truth and try to understand some certain things. Like, you have to do a lot of soul searching. You have to understand that every human being is prone to what we call confirmation bias. So you have a belief and you're trying to get it. There's a tendency to want to interpret any information in a way that supports your belief. And you have to watch her. I got a comment from Laura Murphy. Kevin, tonight on Court TV, continue to be calm and commonsensical, but please don't let Nick continue to run his mouth for hours. He gets too much talk time. I have no control over what talk time Nick gets. In fact, the other night, I felt bad because this has happened to me several times where I went a little too long on the second segment, and so Nick almost got cut off and only got 30 seconds. That's the first time that's happened. But I have no control over what time. It was a little bit. I was kind of in a tough situation, not the last night's show, but the night before shows, because Peter Ellikin clearly. I don't want to bash the guy, but I'm really disappointed in his reporting on this because he doesn't follow the case, follows it very superficially, doesn't seem to want to follow the case. And even so, he brought up the night before, he was on 2 nights in a row. And the night before, he brought up that he didn't understand why the taillight pieces, the red taillight pieces, were found later by the state police buried under the snow, but were not found by the Canton police that morning. This was Turtle Boy's main objection last year. And I explained it away in September to Turtle Boy on the phone and many times on this channel. Why? But if you didn't believe me, if you're following the case and if you're commenting on Court TV, you should be following the case. Lieutenant O'Hara explained that those pieces were found buried under 3 feet of snow. How did it get under 3 feet of snow? He went into detail. They were found basically on the street near the gutter, right where snow was plowed. And he described how he went through the softer snow and then got to another harder snow where there was an older plow bank. So the 3 feet of snow, some of that would have been from plows that probably came that day. But then there was an older plow mound from before John was found at the crime scene. And you can see that plow mound, even though it's grainy, in the dash cam video. Looks to me like it's, I'll try it with my hands. I'd say it's 18 inches to 2 feet in height and width. Now, that's plenty to hide a shoe and to hide taillight pieces. And the Canton police never took a shovel to that scene. They never would have taken a shovel because they knew the Sturt police were going to investigate it. That's why they never found it. There's no excuse for not understanding that now. There's no excuse for not understanding that if you're a lawyer that's going on Court TV. Now, when he said that, I explained it to him right away. And I said to him, Lieutenant O'Hara had already explained why it wasn't found. Well, the very next night, Peter Ellikin is on TV again with me and Nick. And he says the exact same thing, which I find offensive. I guess he's saying, well, this guy's just a YouTuber, so I'm not going to listen to him. But it didn't even spark a question where he said, oh, maybe that's interesting. Maybe that explains what happened. Even if I'm not sure if this guy, Kevin, from YouTube is telling the truth or has it right, maybe I should go investigate it myself and find out what Lieutenant O'Hara testified to, since I'm going on Court TV to talk about this case. But he didn't do that. He went on Court TV and just repeated the same nonsense as though I hadn't explained it to him the night before. And yeah, that stuff bothers me. Sorry, I was getting a message. That stuff really bothers me. I don't know. I mean, this is the problem with the public and getting this stuff out there, that it just this wildly inaccurate information that we're put out there with. But Jason, if you are following the case, I don't get it. Well, obviously, there's more evidence to come. And we're going to find out about the vehicle data and the crash scene reconstruction. But if you believe that there was a conspiracy here, now, all right. So I don't want to put words in his mouth. He said, I see reasonable doubt and not guilty so far. But one thing that people have to understand, and everybody here, most of the people in our chat do understand this, is that this, in one sense, this is an either or. I explained this on Court TV a couple weeks ago, and Joe said it's not an either or, but he wasn't quite getting what I was saying. It's either A or B. Either A, Karen did this, or B, evidence was planted on a large scale and it was rigged. There's no middle explanation where Karen is innocent and evidence was not planted. That's not possible. Now, what Joe was saying was, there are other options in A. Yes, there are multiple options in A. So maybe Karen did it and didn't know she did it. So that would be completely just a manslaughter situation. Or maybe she did it, wasn't sure, and then later on figured it out. So there are degrees of nuance here to exactly what happened. But either But in a real fundamental sense, either Karen did the crime, whether she knew it or not, but she did the crime. Her SUV with her behind the wheel caused John's death, or evidence was planted at a massive scale. It's an either or. And so if you can't, so most of the witnesses that we've seen so far are to dispel the defense's claim that all this evidence was planted. And we have not seen any evidence that evidence was planted, or any even reasonable, plausible explanation as to how evidence was planted. Okay? We now know that the SUV, which was parked in Karen's driveway in front of her Ring video all afternoon, arrived at the Sally Port way too late for that vehicle to be tampered with there. Way too late. And this is why, so you saw Alan Jackson today when he tried to point out that this a few seconds missing in the video. This is a surveillance camera. It's not that sophisticated. You can pull out your Ring video and find the same thing. There'll be little gaps in it. It's not a high resolution camera. It's something with a shutter speed, with a reduced shutter speed. And without getting into details, he's going to say, well, see, there was some guy hanging around, that shadowy figure behind the taillight. But that's the best he can do. But all Lally has to do is point out that evidence was found at 5:45, that the CERT team was there setting up between 5 o'clock and that time, and the vehicle wasn't put into the garage until 5:36. And it's a 5-minute drive to the crime scene. So there was no time for anybody to pry pieces of taillight off that vehicle in the Sally Port, bring it over, and bury it deep in the snow. Deep in the plowed snowbank where the first pieces were found, 3 feet down. It's an impossibility. That door is closed. And you hope that the jury will be smart enough to see that, and I trust that they will. I trust certainly that most of the jurors will see that. You never know when there's one random person that's got their mind made up for some before the trial began. But most of the jurors are going to see through that. I can't help it if the zombies don't see through it, because for them, this has become an article of faith and they don't want to see through it. Now, does that mean because there was no opportunity within the Sally Port, or no time to go plant evidence and to tamper with it there? And certainly we've seen that the taillight was in pieces by 5:30 a.m. anyways. Does that mean it's impossible that it wasn't tampered with at some other time and planted at some other time? Well, I would say not impossible, but again, what are the odds here? So we know that 5:30 a.m., Kerry Roberts saw the taillight and it was shattered in pieces, and she was showed a picture of it taken from zoomed in later in the garage. And she said, yes, that's what I saw. And the defense did not ask any questions. They chose to accept it. So the defense is, any juror, if the defense chose not to question that, they should be accepting that, yes, it was in pieces by 5:30. Oh, okay. So somebody sent me evidence about the motion. Let me go to see if this came by email or by Facebook. All right. Maybe this is a Twitter. Let me try Twitter, because this is someone that normally talks to me on Twitter. All right, here it is. See, I didn't have the Twitter window open, so we do have some information on the motion. So let's pull this motion up. Thank you. I won't say the person's name because I don't think they actually want that. And thank you, Ashley, for the memberships. Appreciate it. And Ashley, I don't know if you saw my message earlier, but I apologize. I couldn't communicate more at length with you yesterday. It was just an incredibly long day that just was so little time. All right, so let me see if I can pull this up where you guys can read it too. All right, I'm going to pull this into the stream I don't know if it'll be large enough for you guys to read, but we'll pull it in. And thank you for the person who sent me this, much appreciated. All right, even I can't read this, so I'm going to, let's see if I can make this a little. Oh, okay, there we go. All right. So, motion from the Commonwealth. On April 15th, 2024, the day prior to trial, the defendant provided the Commonwealth with a witness list which contains the names of civilians, police, defense investigators, and experts. On April 22nd, the Commonwealth filed Commonwealth's renewed motion for reciprocal discovery and renewed request for voir dire of any proposed defense experts. During that week of jury impanelment, the defendant was ordered to comply within 1 week. And so on that was on April 14th. On April 29th, opening statements. I'm not sure if that 14 is for a date, so it might be there for something else. So on April 22nd, the Commonwealth filed the motion for this reciprocal discovery. During the week of jury impanelment, the defendant was ordered to comply. So I think that week of impanelment was the first week of May. On April 29th, opening statements were made. Okay, so it was last week of April, actually. So on April 29th, opening statements were made and the trial testimony commenced. The defendant sporadically provided reciprocal discovery to the discovery on May 1st and May 7th. So that's well outside of the week that they were ordered, allowing the defendant to withhold such evidence against a witness who is certain to be called to testify that would undermine the discovery rules and allow attorneys to return to trial by ambush. Theatrics do not accord with our discovery process. The defendant has failed to comply with the code, which requires the defendant to produce all intended expert opinion evidence, including all written reports and opinions that pertain to this case. So it looks like they're going to try to get a witness or witnesses excluded, right? Read it again. So there are rules that once the state has signed a form saying that they've complied with all discovery material, then the defense has to comply within a certain amount of time with reciprocal discovery, and they were given a week. Some reciprocal discovery was provided on May 1st and May 7th. So that is after the week. So they were given a week by the court on April 29th. May 7th is just outside of a week, but probably close enough. But it is outside of a week. May 1st is within the week. So it's pretty close. A defendant's discovery obligations include impeachment evidence, allowing the defendant to withhold such evidence against a witness who is certain to be called to testify would undermine the discovery rules. So impeachment evidence, this is something that goes against the credibility of the witness. So the state is saying that for one of their witnesses, and we'll have to just guess on who, that the defense withheld possible impeachment evidence that would have gone against their credibility. So let's see what you guys think about that. I will send that motion to Kevin, although there's not specifics in it, so we don't know what it's actually about. Laura says, I do a great job. I think you're talking about Court TV, almost too clear. I got to go post those episodes from the last few days on. I usually do that because they're hard to find. But there was one from a few days ago that I goofed. I made a mistake. Actually, at first it happened during the day when I think it was during Lieutenant O'Hara's testimony, and O'Hara reported that the entire search team was finally present and began their official search at 5:41 at the crime scene. And for some reason, and I don't even remember saying it here, but I must have had a brain fart and I said 7:41, and people corrected me in chat. But then once I had the correction in my mind, I guess it just couldn't dislodge. And when you're on court TV, it's like you're trying to cram in as much information you can into like 40 seconds. And so I made a mistake, and I again repeated the 7:41. And I don't know if anybody caught it, but I felt embarrassed about it enough that I didn't want to post a link to that episode, but I'll post it. And then so I got to post 2 or 3 from with Vinny that I haven't posted, and 1 from Julie Grant from yesterday. I also made another mistake in that same one as the 5:41 episode. I was talking about the hair, and I said, if you were going to plant that hair on the back of the car, would you plant it on a horizontal surface, is what I said. What I meant was vertical. What I meant to say was you wouldn't plant it on a vertical surface. You would plant it on a horizontal surface like the bumper. So it's like, imagine if you're going to plant a human hair on the back of a car. Would you just lick your finger and then stick it on the vertical surface of the car panel where it's might fall off? No, you wouldn't do that. So I made those 2 big goofs and felt bad about them. You don't get a chance to correct yourself when you're in such a short show like that. Another problem that I had with the one from a couple of nights, not last night's, but from a couple of nights ago, and maybe I tried to be shorter in my answers last night because of this, but in the night before, in the segment, Vinny would list the 3 major points or basis for reasonable doubt, and he listed Collins Knuckles, the 227 search, and I forget the third one, but they were 3 major parts of this. I think maybe it was the taillight pieces. So I have like 30 seconds, maybe a minute to reply to all 3 of those things. And they're all significant things that can easily be explained, but they do require some time to explain them. So my answer got a little bit long, and that was the episode that I think Nick cut short. But it's really because the way it was presented to me, I had too many questions to answer in one short segment. So, but thank you, Nikki Dobson. I appreciate it. Doing the best I can. So, all right, let's wrap this up here because I am starved and I'm ready for lunch. And I want to thank you, everybody who contributed things to us. Chris, I didn't even, that was earlier. Ashley, thank you. Scott, Sailboat, Chris, Boxer Clover, 65, CJ, and Bill, and Laura. I'm sorry, Lou Morocco, Morocco. But thank you guys. I appreciate it. I'm wrapping up, so don't contribute anything right now because then that makes me stay on. So please don't. I just wanted to say thank you. So don't contribute anything more. Appreciate it. Saying thank you. And we will see you guys tonight at 7:15. And I will have Tom Fleming with me. Everybody enjoyed him. And he's giving me 7 o'clock. All right, we'll do it at 7. You got a deal, Tom. We'll do it at 7. So 7 o'clock. And I think Dave McGrath will be with us too. And so we'll go over this. And this case is really starting to get a lot more clarity.